ಇನ್ನೊಂದು ಕೆಳಗಡೆ ಒಂದು ಬಂತು, ಅದನ್ನ ತೊಗೊಂಡೆ. ಇದರಲ್ಲಿ 2 ಆಪ್ಷನ್ ಬಂತು.
ಟ್ರೈ ಅನದರ್
ಅದು ಕೆಳಗಡೆ ಅದನ್ನು ಇನ್ನೊಂದು ಬೇರೆದು ಇದು ಬಂತು.
ಚೂಸ್ ಮಾಡಿ. ಇನ್ನೊಂದ್ರಲ್ಲಿ ಯಾವುದಿದೆ ನಿಮ್ದು? ಕೇಬಲ್ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ವಿ ಸರ್. ಈಗ ರೆಕಾರ್ಡಿಂಗ್ ಆಪ್ಷನ್ ಮಾಡ್ಬೋದು ಸರ್. ಅದು ಇದೆ ಸರ್. ಸಿಸ್ಟಮ್
ಇದು ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್, ಬಟ್ ಇದಕ್ಕೆ ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು ಆಪ್ಷನ್ ಇಲ್ಲ. ಇವಾಗ ರೆಕಾರ್ಡಿಂಗ್ ಆಪ್ಷನ್ಸ್ ಇದೆ.
ಎಸ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು ಕೊಡಿ ಎಲ್ಲ ಅನ್ಲೆಸ್ ಫಾರ್ ಆಫ್ಟರ್ನೂನ್ ಅಂದ್ರೆ ಎಲ್ಲ ಕೊಡಿ. ಬಿಡಿಎನಾ ಎಲ್ಲೇನು ಯಾವ್ದು ಎಲ್ಲೇ ಯಾವತ್ತಿಲ್ಲ. ಎವ್ರಿ ಡೇ ಕನ್ವೀನಿಯನ್ಸ್. ನಾಳೆನೇ
serial number 50 and 52, your lordship. 42. Page 11, serial number 46 to 47.
Which one, Mr. Arun? CL number? CL number, yeah. 47. Have you informed the respondent? Have you informed the respondent? Any objection? 47. So, Shanmugappa has entered appearance for the petitioner. When the registry is directed, delete the name Sankarnayan Rao BV as that appearing for the petitioner. Yeah, respondent Gyaro? Vivek Yavagal. Vivek Yavagal is appearing. N.R. Girisha. Respondent Shri N.R. Girisha has entered appearance for the respondents. Registry is directed, delete the name of Shri Vivek Yavagal as that appearing for the respondents. The counsel for the petitioner seeks for and is granted 2 weeks time. Relist from 8/6. Oh, sorry, 7/6. Interim order earlier granted is extended till next date.
That's serial number 50, Your Lordship.
Just a moment. 45. Yes. And AGA accepts notice for respondent number 1. Counsel for the petitioner seeks for and is granted a week's time. Relist on 31/5. 50 page alilla. Page not funded.
Page 12. Number 48.
Already 50. You're for? 50. The request of the counsel for the petitioner relist on 31/5.
Serial number 50, Your Lordship. I am for responding. 50.
Even the petitioner wants time, Mr. Kiran. We'll have it on 31st.
Much obliged, Your Lordship. And also 52, Your Lordship. I am also for responding. Petitioner Mr. V. Gunjal is also there in the video conference.
Mr. Gunjal?
Serial number 52, Your Lordship.
Mr. Vardhan Gunjal.
We are shifting office. The file is not able.
You are shifting office.
Yes, yes.
But then please inform Mr. Gunjal who is
Definitely, Your Lordship. I will.
52.
58.
Counsel for respondent seeks for and is granted a week's time. Relist on 31/5.
Lordship, not on 31, Your Lordship. Any other day except 31, Your Lordship.
50 ಗೆ 31/5 ಬರ್ತೀರಾ ಅದಕ್ಕೂ 31/5 ಬನ್ನಿ ಅಂತ
31/5 Keshav Narayan committee hearing ಇದೆ Your Lordship.
So ಹಾಗಾದ್ರೆ 50 ಆಗಲ್ವಾ?
Lordship,
50 CL number 50 we have posted on 31/5.
Lordship, both the matters I will request Your Lordship.
50
Any other day. First or second is also fine, Your Lordship.
Please inform Mr. Abhinay that the date is changed.
Yeah, I will inform Abhinay also.
31/5 in our problem and we'll have it on 50. The request of the counsel for the respondent relist on next date 7/6. 52 at the request of the counsel for respondent relist on 7/6.
Lordship, serial number 51, I seek an adjournment in this matter.
You are appearing for whom, madam?
I am for the petitioner in this matter, Your Honor.
Have you informed the respondent?
I'll keep them informed, Your Honor.
Today we are adjourning, but from tomorrow, please don't mention if you are not informed the other side.
Please.
The basic courtesy is for the other side to be informed.
Please, I'll do that, Your Honor.
If you don't inform and move it, we will reject your request. You may feel bad. 51.
Lordship, there's also an interim order in this matter.
That is why you have to inform.
I'll do that.
I want adjournment. We won't extend the interim order. That's why let it come in the usual course. We're not adjourning.
Please.
Next.
My lord, serial number 55, my lord.
55. Yes.
Please, for the petitioner, my lord. Kindly have it.
Will you inform the respondent, madam?
I shall inform, my lord. I will inform, my lord.
Shall beda. We are
Sorry,
not
my lord.
adjourning the matter.
My lord, I shall inform, my
We
lord.
are also sorry, we are not adjourning. Next. Have you informed the petitioner? He has no objection. Because once you mention it, if they come and say, even if you are not there, we'll take it up. That is the condition of adjournment. 56. At the request of the counsel for the respondent who submits that he has already informed the counsel for the petitioner, relist on 31/5. Have you informed the petitioner? ಇವತ್ತಾನೆ ಎಷ್ಟು ಸತಿ ಹೇಳೋದು ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ, ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಬೇಡ. 51 in your for second respondent. Our mention ಮಾಡಿದ್ರು we did not grant because interim order ಕೇಳಿದ್ರು, extend ಮಾಡಕ್ಕೆ ಪರವಾಗಿಲ್ವಾ? 51. The counsel for the respondent number 2 seeks for and is granted 2 weeks time to file his rejoinder. Statement of objections. Statement of objections, if any, to be filed on or before 3/6/2022. After serving a copy thereof on all the other counsels, relist on 7/6/2022. The interim order earlier granted is extended till next date of hearing. 49. A page kardaವಾಗ ಬರಬೇಕು ನೀವು. Have you informed the respondent? Respondent inform ಮಾಡಿದ್ದೀರಾ? Will ಬೇಡ. Will ಅಂದ್ರೆ there is a litigation. ಬೇಡ. Who has entered appearance? But this is not a matter to be mentioned and adjourned. We don't know what the petitioner says. ಬಂದೋಗಿ ಅದಾದ್ಮೇಲೆ ಮಾಡೋಣ. We can't do partial orders. 68. Yes. Have you informed? 68. The counsel for the petitioner seeks for and is granted a week's time. She submits that she has informed the counsel for the respondent who has no objection for the adjournment. Relist on 31/5.
Serial number 73 and for the petitioner in this matter, have informed the respondent.
73.
2 weeks time you can
ಏನಕ್ಕೆ 2 weeks?
take instructions from my client. You know, it has become innocuous.
2014 matter, Mr. Sathya.
I do understand. 2 weeks time you can.
We are listing only until 2015. That is why we won't be granting adjournment because these are old matters. 2 weeks alla kodala, 1 week. 73 at the request of the counsel for the petition mentioned at 10:30 at the request of the counsel for the petitioner released on 31/5.
31/5 next week. First week of.
ಅದೇ 2 week ಆಗೋಯ್ತು.
First week of 13/5.
ಇದು ಬರೀ ಟ್ಯೂಸ್ಡೇ ಬಿಡಿಎ, ಅದಕ್ಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳೋದು. ಒಂದೇ ದಿನ ಇರೋದು ಒಂದು ವಾರಕ್ಕೆ, ಅದರಲ್ಲೂ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. 7/6. Yes. 74. What's your name, madam? You are holding Vakaratnama? You have signed the Vakaratnama? Srimati Ms. Deepika, who appears for the counsel for the petitioner, submits that the above petition has been rendered infructuous. Accepting the submission, the petition is dismissed as infructuous.
Serial number 75 to 85.
Serial number 78, my lord.
79 at the request of the council. The order dictate ಮಾಡೋದು. 79 at the request of the counsel for the petitioner, relist on 7/6. They are responding. Yaar appear aagta hai. Sudev Hegde na Sachin. You are appearing now. Since Shri B.S. Sachin has entered appearance to the respondent, registry is right. Delete the name of Shri M.N. Sudev Hegde as that appearing for the respondent.
Number 82.
Video la Sundaresh ಅವರು ಇದ್ದಾರೆ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ 82 council has to be informed. ನಿಮ್ದು 82 ನೋ 85 Serial number 82 mentioned at 10:30. Learned counsel for the petitioner seeks for and is granted 2 weeks time. He submits that he has informed the counsels for respondent who has no objection for the adjournment. Relist on 7/6.
With your lordship's kind leave, my lord.
Why? 27th is not a date for these matters. It will be taken up on 31st. 85 at the request of both the councils, relist on 31/5.
With your lordship's kind leave, my lord. Serial number 78, my lords.
Just a moment, please. Inform ಮಾಡಿದಿರಾ? ಯಾರು? ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿರೋದಕ್ಕೂ ಅವ್ರ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸಿಂಗ್ ಸಂಬಂಧ ಇಲ್ಲ. ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? Wait, he is not here. Yes, somebody else mentioning on the VC.
Serial number 78, my lords. I am appearing for the petitioner in this matter. My lords, the petitioner, I am informed that the petitioner died on 10/2/2020, my lords. I shall file necessary applications. The matter may kindly be taken up.
78,
my lords.
learned counsel for the petitioner submit that the sole petitioner has expired and hence he seeks for 2 weeks time to file necessary application to bring the legal representative of deceased petitioner on record. Relist on 7/6.
Much obliged.
ಆತ ಯಾವಾಗ ಅಪ್ಲೈ ಮಾಡಿದ್ರು? Who appears for BDA? Shri Manjunath accepts notice for respondent number 1 and 2. Notice to respondent number 3 to 5 is dispensed with for now. Shri Manjunath seeks for and is granted a week's time to make his submissions. Relist on 31/5. Why is data pending from 2019? Are you web hosting the Kata applications? How are you keeping track of it? What is the time period taken for Kata? You will have to tell us on 31/5. Hmm.
2018 is commence day when requested to PDA. Nearly 30 documents have been given to them as and when they require. Till now
They are not responded only.
They are not responded.
BDA council is listed, yeah.
There has been a raid in the PDA therefore.
BDA council is listed, yeah. Who else is there? BDA council. Mr. B.S. Sachin accepts notice for respondent. He seeks for and is granted a week's time to make a submission. Relist on 31/5. Mr. Gunjal.
petitioner.
Yes.
Petitioner is senior citizen, and he is about 89 years of age. My petitioner was asking for allotment number 30/40 plot in a layout owned by the respondent authority. The petitioner or neither of our dependents have any residential.
Who else is there from BDA? BDA council ಇನ್ಯಾರಿದ್ದಾರೆ? We'll be one list ತೆಗೆದುಬಿಟ್ಟು we'll be circulating each matter to one.
The petitioner was desirous of.
Yes, madam, we are issuing, we are giving them notice. Let us get so accept notice for respond number 1. Respondent. He seeks for and is granted a week's time. Released on 31/5. Mr. Madhusudan. Mr. Prasanna Kumar is no longer appearing, Mr. Chen. Mr. Prasanna Kumar is no longer appearing. Where are respondents? Both are BD only. So you appear for both.
Yes.
Really? ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಸೀನಿಯರ್ ಅಂತ ಹೇಳ್ಬೇಕು. BS Sachin has entered appearance for the respondents. Registry direct delete the name of Shri CR Gopal Swami and Associates and P. Prasanna Kumar as that appearance for respondents. In view thereof, the memo of retirement filed by Shri P. Prasanna Kumar is accepted. What is this IA considered? 7. We list on 7/6 at the request of council for the petition. You have filed the amended cast title, you have to amend. What about respondents in the NOCs? Who is appearing now? Nobody is appearing. Mr. Kiran?
Serial number 5, I appear for respondent, Your Lordship.
You appear? You filed your wakalat?
Yes, Your Lordship. NOC wakalat has been filed, Your Lordship.
Kiran CD has entered appearance for respondent number 2. Registry direct delete the name of Shri M.N. Sudev Vegadev, Shri Vivek Yaugal. Is that appearing for respondent number 2? Who appears for respondent number 3? Puttegoda, Devendra Panagala.
It is a Puttegoda, Your Lordship.
Devendra for Israel. Mr. Puttegoda. Yardamali Wakalate. Current counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendments. Released on 31/5.
Lordship, not on 31/5, Your Lordship.
Sorry, 7/6.
Much obliged, Your Lordship.
Current counsel for the petitioner, respondent number 2, submit that he has served a copy of the statement of objection on the petitioner, which is confirmed by the counsel for the petitioner. Yes. Fine. Today you receive. Released on 31/5. And Shri B. Vachan has entered appearance for respondent number 2 to 4. Memo of retirement filed by Shri Vipin Egide is accepted. Registry is directed. Delete the name of Shri Vipin Egide as that appearing for respondent number 2 to 4. Yes, Mr. Sampath. Ready? Ready now? Good. Mr. Vachan has no objection to allow the petitioner, Mr. Vachan.
Lord, I'll file my objections, my lord. This is in
Objections ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ no objection.
ಇಲ್ಲ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. I'll file.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
2 weeks time I kindly be granted.
2016 matter ಯಾಕೆ Mr. Vachan?
NOC ವಕಾಲತ್ ಬಂದಿದೆ, ಸುಮಾರು NOC ವಕಾಲತ್ ಮ್ಯಾಟರ್ಗಳು ಬಂದಿದೆ. I have to file my ವಕಾಲತ್ in all these matters. Objections in all this.
ಎಲ್ಲ ವೇಕೇಶನ್ ಕೂತ್ಕೊಂಡು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ಬೇಕಾಯ್ತು.
Some of them I have done it, some are pending. I'll do it, my lord.
B. Vachan, Learned Counsel seeks for and is granted 2 weeks time to file his objections. Statement of objection. Objections if any to be filed on or before 3/6/2022 after serving a copy thereof on the counsel for the petitioner. Relist on 7/6.
My lord, one submission is serial number 9, my lord. Serial number 9.
Mr. Vasant, we are in serial number 8 right now.
Oh, sorry.
We'll take your submissions after we come to serial number 9. Yes, Mr. Nandaswamy. What about respondents? ಯಾರು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ರಿ ಇವಾಗ? ಎಲ್ಲ NOC-ಗಳೇ ಇದಾವೆ. Shri V.K. Narayanaswamy has entered appearance for the petitioner. Hence, the memo of retirement filed by Shri Lohitashwa Banakar is accepted. Registry is directed to delete the name of Shri Lohitashwa Banakar as that appearing for the petitioner. Shri Murugesh Charati has entered appearance for respondent number 2 and 3. Hence, registry is directed to delete the name of Shri M.N. Ramanjane Gowda as that appearing for respondent number 2 and 3. Ready? 10th. Released on 14/6 at the request of counsel for the court. Interim order they are granted is extended till next date of hearing. Nine.
My lord, in this,
Mr. Vasant?
my lord, this matter, it has been disposed of on 4/3/2020, my lord. And for the implementing
Disposed of
application
on 4/3/20.
4/3/2020, the matter came to be dismissed. On the same day, I filed the implementing application. Probably that has not been shown in the cause list.
On the same day you filed what?
I filed the implementing application to implead myself as a respondent, one of the respondents.
Dismiss ಆದ್ಮೇಲೆ impleading application ಹೆಂಗ್ ಬರುತ್ತೆ Mr. Vasant?
ಬರಲ್ಲ, ಅದು ಡಿಸ್ಮಿಸಲ್ ಆಗೋಗಿದೆ, ಅವತ್ತೇ ಆಗಿದೆ ಡಿಸ್ಮಿಸ್, ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. ದಟ್ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ನಾಟ್ ಪುಟ್ ಅಪ್. ಬರಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ.
Now you can take whatever steps you intend to take. The page of the order sheet indicates that the above matter had been dismissed on 4th March 2020 itself. The Registrar Judicial is likely to look into the matter as to why it has been listed today. Since the matter has been dismissed on 4/3/2021, so nothing requires to be done.
Much of it.
I appear for the respondent, your lordship. Respondent 1 and 2.
Non-furnishing, non-rectification of office objection. IA 2 of 18 ಯಾರು ಹಾಕಿರೋದು? ನೀವೇ ಹಾಕಿರೋದು. So now who is appearing? Mr. Kiran BS is appearing. Ramesh Chandra ಅವರು ಇಲ್ವಲ್ಲ? Shri Kiran BS has entered appearance for the petitioner. Registry is direct delete the name of Shri Ramesh Chandra as that appearing for the petitioner. Shri Kiran CV has entered appearance for respondent number 1 and 2. Registry is direct delete the name of Shri M.N. Ramanjane Gowda as that appearing for respondent number 1 and 2. Counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee and furnish copies. If the process fee is not furnished by 27/5/2022, how many times is it gone? ಎಷ್ಟು ಸತಿ ಹೋಗಿ ಬಂದಿದೆ ಸಮಸ್ಯೆ, ಇನ್ನ ಒಂದ್ಸತಿ ಹೋಗ್ಬಾರ್ದು. If the process fee and copies are not furnished by 27/5/2022, the petition would be liable to be dismissed against proposed respondent number 6, 7, and 9. Where counsel for the petitioner seeks for and is granted a week's time to comply with the office objection on IA number 2 of 2018. The same to be complied with on or before 27/5/2022. Relist on 31/5.
Your Lordship, 31, then, Lordship, not on 31.
Relist on 7/6.
Much obliged, Your Lordship.
I'm appear for the petitioner, my lord.
Yes.
2 days time, my lord, I carry out the amendment and file the amendment petition.
There's a reason why we have put 80% correctly value. And there's also circular. We should very well, which is applied at the Supreme Court also.
Yes, Mr. Bhatt.
My lord, after 2 days time, my lord, I comply the file. My lord, my lord.
ಅಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿರಂತೆ, ಬಟ್ ಏನ್ 18% is what they've imposed, which has been already upheld by a division bench and the Supreme Court.
Kindly taken off day after tomorrow, my lord. My senior is not well.
Council seeks for and is granted 2 days time to comply, to carry out necessary amendment. If the amendment is not carried out by 27/5/2022, the petitioner will lose the benefit of the order of amendment. Relist on 31/5.
For the applicant in this case, my lord. Well, applicants are the LRs of the sole petitioner who passed away on 22/7/2020. Now have filed these applications to bring the applicants and record it. So it appears that there are some objections. I'll just do the needful, Your Lordships, in a week's time.
I'm yet to receive a copy. I have not received a copy of the applications.
You have not received. Copy ಕೊಡಿ ಅವರಿಗೆ, ಅದೇ objection ಇರೋದು ಅದೇ.
All right, Lordship. I'll do the needful. I'll give the copy.
Chairman,
yes.
Objections is that you are not furnished.
All right,
number of delays is not mentioned. ಯಾಕೆ ಇದು ನಿಮ್ಗೆ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಏನು objections ಇದೆ ಅಂತ?
No, website ಅಲ್ಲಿ so far as the applications are concerned.
Website ಅಲ್ಲಿ objections ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
So far as the applications are concerned, Your Lordships, in case if it is a fresh matter, we'll get to know that what are the objections. But this is based on applications. I'll just do the needful.
Counsel for the petitioner seeks for and is granted a week's time to comply with office objections on IA 1 of 22 to 3 of 2022. Shri Hemant Kumar D, learned counsel for the petitioner, submits that he was not aware of the objections raised on the said IAs, since they are not web hosted, and as such he could not comply with the same. In many matters, this same situation is faced by this court. Hence, the Registrar Judicial is directed to ensure that office objections raised on interlocutory applications are also web hosted and a compliance report is filed in the present matter. At the request of the counsel for the petitioner, relist on 7/6. Counsel for the petitioner seeks for and is granted a week's time to furnish process fee and copies. If the same is not furnished by 31/5, the petition against respondent number 4 would be liable to be dismissed for non-prosecution. Relist on 7/6.
I appear for the petitioner, madam. Yes. I pray for a week's time, madam. I will comply with the office.
Same order. Dismissed against respondent number 5. ಯಾರು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ? So is it Mr. Gopal Bilamane or BG Shankar Rao? latest aura. Mr. Shankar Rao. None appears for the respondent today. Released on 31/5/2022. It is made clear that if none were to appear for the respondent on that date, the matter would be taken up for consideration in their absence. 16.
And for the petitioner, my lord. But I haven't taken steps of twice, my lord. They have not received. I think they are avoided to receive the notice. Kindly, my lord, the one Sachindra Karanta is representing on behalf of the respondent 2 and 3. Can you direct him to take notice? I will serve the copy to him, my lord.
2 and 3 yaro?
Sachindra Karanta is the representing on behalf of the
authority, na?
Pardon, my lord? No, that's the association. Association. Yes, my lord. The one and
the president BDA.
1 and 4 is the authority. There is a BDA. 3 and 4 is the
Yaru
association.
standing council idara 2 and 3.
Yes, my lord. The Sachindra Karanta is the standing council, my lord.
Mr. Sachindra Karant.
Yes, Sachindra Karant. Can you direct him to take notice? I'll send the copy to me.
That Shri Sachindra Karant is the standing counsel appearing for respondent number 2 and 3.
Yes, my lord.
Hence, he is directed to accept notice. Registry is directed to print the name of Shri Sachindra Karant as that appearing for respondent number 2 and 3. Counsel for the petitioner is directed to furnish copies of the petition along with annexures on Mr. Karant. Released on 7/6.
That's all.
Mr. Tippaswamy. None appears for the petitioner. 2 weeks' time is granted to the petitioner to do the needful. If the needful is not done by 3/6/2022, the petition will be liable to dismiss for non-prosecution. Relist on in authority. 1 and 2 yaro? You are inaugural. Who else is there for phone wrapping first? ಇನ್ಯಾರಿದ್ದಾರೆ ಇಲ್ಲ ಬೇರೆ ನೀವು ಬಿಡಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ? ಶ್ರೀ ಅಜಯ್ ಕುಮಾರ್ accepts notice for respondent number 1. If process fee and copies are not furnished insofar as respondent number 2 weeks from today, the petition will be liable to be dismissed against respondent number 2. We list on 14/6. Petitioner to furnish a copy of the petition along with annexures on Shri Ajay Kumar. ನೀವು NOC ಕೊಟ್ಟಿದ್ದೀರಾ? ನಿಮಗ್ ಬಂದಿದೆ. ಸೊ ಶರತ್ ಗೌಡ ಅವರ ಹೆಸರು ತೆಗಿಬೇಕು. ನೀವು 19 ಬಯಾರೆಡ್ಡಿ ಅವರ ನೀವು 19 ಅಲ್ಲಿ 18 ಇವಾಗ 18. What is the objection on IA1? Copy not served. Sir, ಮಾಡಿದ್ದೀರಾ? ಇವಾಗ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Learned counsel for the petitioner has today served a copy of IA1 of 2021 on the counsel for the respondent. Hence, the office objection stands complied with. Learned counsel for the respondent speaks for and is granted a week's time to file their objections. You are the new Ravi Kumar, huh? Sure. Okay. Since Sri Sarath Gowda has entered appearance for Ejana either petitioners. So the petitioners in WP number 4545 of 2020, registry is directed to delete the name of Sri C. Ravi Kumar as that appearing for the petitioner. Same, 18.1 same. 18.1 ನಲ್ಲಿ, since Sri Murugesh Charati has entered appearance for respondent number 2, registry is directed to delete the name of Sri Loknath as that appearing for respondent number 2. Pre-list on 14/6. And Sri N. Bayareddy has entered appearance for the petitioner. Registry is direct to delete name of Sri J.M. Rajanna Setti as that appearing for the petitioner. R3 yaro? Private party. So yav padtira? So again ಮಾಡೋದು. No such person ಅಂದಾಗ paper publication ಹೆಂಗ್ ಕೊಡ್ಬೋದು Mr. Bayareddy? So find out the correct address. You want them to be a party, so you have to give the address. You cannot say paper publication. Paper publication, if they are residing in Bombay, ಇಲ್ಲಿ ತಗೊಂಡು ಎಲ್ಲಿಗೆ ತಗೊಂಡ್ಬೇಕು? Sri N. Bayareddy seeks for and is granted 2 weeks time to furnish the proper address. A week's time to furnish the present and proper address of respondent number 3. We list on 31/5. Mr. Shiv Prakash. None appears for the petitioner. There 1, 2, 3. 3. Then a DG accepts notice for respondent number 1. Innobra Videga. Anjanath K accepts notice for respondent number 2 and 3. Petitioner is directed to furnish copies of the petition and along with annexures on the said councils within a week from today. We list on 14/6.
My lord, serial number 23, my lords.
21, madam.
Okay, my apologies, my lord.
Where respond there? Sri K. Krishna accepts notice for respondent number 1 and 2. None appears for the petitioner. The petitioner is directed to furnish copies of the petition along with annexures on Sri K. Krishna. Relist on 14/6. Yeah, respondent sir. ಯಾರಿದ್ದಾರೆ ಬಿಟಿಗೆ ಇನ್ನೊಂದು Sri Lakshmish accepts notice for respondent number 1 and 2. None appears for the petitioner. The petitioner is directed to furnish a copy of the petition along with annexures on Sri Lakshmish. Relist on 14/6. Yes, madam. 23.
Appearing for petitioner in this case, my lord, I may be permitted to take notice to respondent number 2, Mr. K. Krishna, BDA Council, my lord.
ಚೇಂಜ್ ಆಗಿಲ್ಲ ಆ ಲಿಸ್ಟ್ 4 ಜನ ಅಷ್ಟೇ ಇದ್ದಾರೆ ಅಂತ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Mr. Krishna, only 4 people are there. BDA. ಆಯ್ತು ಕೊಟ್ಟಾಯ್ತು ಅವ್ರಿಗೆ. We don't want to say ಒಬ್ಬರಿಗೆ ಜಾಸ್ತಿ ಕಮ್ಮಿ ಬೇಡ ಅಂತ, ಒಬ್ಬೊಬ್ಬರಿಗೆ ಒಂದೊಂದು. ಇವಾಗ ಇನ್ಯಾರಿದ್ದಾರೆ ಹೇಳಿ? ಇಬ್ರು ಅದು ಹೇಳಿ ಆಯ್ತು. ಮುರುಗೇಶ್ವರ ರೆಡ್ಡಿ ಅವ್ರು ತಗೊಂಡಾಯ್ತು, ಅವ್ರ ಕೋಟ ಮುಗೀತು. ನೆಕ್ಸ್ಟ್ ಸಚಿನ್ ಕೋಟ ಮುಗೀತು, ನಿಮ್ದು ಮುಗೀತು, ಅಜಯ್ದು ಮುಗೀತು. ಅಲ್ಲಿ ಬರ್ಕೊಂಡು ಬಿಡಿ. Sri S.T. Basaraj accepts notice for respondent. Learned counsel is directed to accept notice for respondent. Learned counsel for the petitioner to serve a copy of the petition and annexures along with annexures on Sri S.T. Basaraj.
Yes, please.
Since Srimati Annapurna Bardale has entered appearance for the petitioner, registry that delete the name of Sri Nitin A.M. as that appearing for the petitioner. Relist on 14/6.
Much obliged.
24. When ADA accepts notice for respondent number 1. This they repeat my Sri Murugesh Charity accepts notice for respondent number 2. None appears for the petitioner. Registry the petitioner is directed to furnish a copy of the petition along with annexures on Sri Murugesh Charity. Relist on 14/6. Why haven't you served it on Ms. Lakshmi? Lakshmi Rao accepts notice for BDN or the respondents. Counsel for the petitioner is directed to furnish copy of the petition along with annexures on Sri Lakshmi Rao. Relist on 14/6.
Appearing for the petitioner in this matter, my lords. If I may request, my lords, your lordship may kindly see the order dated 23rd March 2022.
Mr. Shetty, who are you appearing for?
For the petitioner, my lords.
No, which counsel? Who is your instructing counsel?
Suhas TL, ma'am.
Suhas TL and Rajesh M.
Yes, my lords.
Since Sri Suhas TL and Rajesh MD have entered appearance for the petitioners, registry is directed to delete the name of Sri Veeranaji Tigadi, KB Monish Kumar and Ravi B. Nayak and Rahul Karyappa as that appearing for the petitioners. Respondents R5. Who appears for R5 now?
I think it's party in person is appearing in for R5. Anil Kalagi, my lords.
Since Sri Anil Kalgi. R5 is on this video. Who is for respondent number 5? You are R5. You are appearing party in person. Mr. KT is appearing. Mr. KT?
I can't see him online, my lords.
NKT has entered appearance for respondent number 5. Registry is directed to delete the name of Sri Balachandra YS and Ram MK as that appearing for respondent number 5, as also the name of respondent number 5 appearing as party in person. Respondent number 6, are you there?
Bestcom, my lords. KPTCL, my lords. It is represented by
respondent number 6.
Yes, my lords.
26, who is appearing for? So Mr. Gachinmat is no longer appearing. Since Sri Shirish Krishnan and Joseph Anthony have entered appearance for respondent number 6, registry is direct delete the name of Sri Gurudev Gachinmat as that appearing for respondent number 6. 4 Sangana. Okay. That's fine. 26.1 Nalli.
Please, my lord. The lordship may kindly see.
Sachin 224, Virana Tigdi for 5, Nitin for R6. For Virana Tigdi is retired in 26. So will your instructing counsel be appearing in 26.1?
Yes, 26.1. Yes, my lord. He says he'll be appearing, my lord.
Has he filed Wakalat, Mr. Shetty?
Is not. He's filing it. Not yet filed, my lord. He'll file it.
TL. Submit that you would be entering appearance for respondent number 5. Mr. Nitin is for R6. Yes, Mr. Shetty, what do you want to say in 26?
Yeah, if I may request, your lordship may kindly see the order dated 23rd March 2022, my lords.
23rd March.
Please, my lords, in WP number 31982 of 2013. That's the first matter. On perusal of the record, on hearing so and so, so and so and so and so, the learned counsel was filed wakalat to the first and third responding WP number. So office is directed to delete so and so, so and so, so and so, my lords. Then, my lords, BDA, certain orders have been passed by the Bangalore Development after this court order dated 29 September 2019 he will secure the complete instruction, place material on record by the next date of hearing. The office is directed to list the matter on 4/4, my lords. After that,
Yes,
also,
Mr. Sachin, what are the instructions you have received? You filed a memo. Date, no? What is the date of the memo? Yaudral file ಮಾಡಿದ್ದೀರಾ?
If I may assist,
ಯಾವ matter file
4th
ಮಾಡಿದ್ದೀರಾ?
April 2022.
You don't see any memo of 4th April ಅಲ್ಲಿದೆಯಾ? ಇನ್ನ ದೊಡ್ಡ ಫೈಲ್ ಇದೆಯಾ? There's a memo filed, Mr. Shetty.
No, the court direction is in compliance. Your Lordship may kindly see the actual order is dated 20th September 2019. He can't file a memo. He has to do he has to file an affidavit or document supporting the affidavit pursuant to that, Manoj. 20th September.
What is 26/9/19 order?
20th April. That is regarding inspection and with regard to granting of occupancy certificate, Manoj. My lords got it, my lords. It's at, I think, 108 of the order sheet, my lords. Page 108 of the order sheet.
It's not 26/9, it's 29.
20th September 2019. 20th September 2019.
Petition is directed to submit a modified development plan and within that, without the vigilance for that plan that is already submitted to the plan. The modified development plan and within plan shall be concurrent with the construction order. The said modified development plan and building plan shall be considered by the respondent board, and if it is found that building plan is not violating of the act or rule, the same shall be considered positive. The modified development plan and the building plan shall be submitted to the authority within 2 weeks. If such a modified development plan and building plan is submitted within 2 weeks, change shall be considered as expensive in the manner at any rate within a outer limit of 4 months.
My lord, pursuant to this, they have filed only a memo, my lord. They have not stated any affidavit. They have not. There is no compliance of the court order.
What is the court order, Mr. Shetty?
Ultimately, my lord, the court had directed us to file a application.
You were directed to submit a modified development plan. Have you submitted?
Yes, my lord, that has been done. So
You
therefore, whether
shall be in consonance with the construction. The said modified and the building plan shall be considered. What have you done on the modified plan?
I like to draw my lord's attention.
The memo put here. Page number?
Page 18 of my memo, that is document number 12. That is 27/12/2021.
Yes.
My lords, we have given intimation, my lords, to the petitioner. My lords, I would like to draw my lord's attention to paragraph number 2.
ಪರಿಶೀಲಿಸಿದಾಗಿ
ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಕ್ರಿಯಾ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 47 ಮತ್ತು 35ರಲ್ಲಿ 34 ಎಕರೆ 20 27 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಪ್ರದೇಶ ಭೂಸ್ವಾಧೀನ ವಿಭಾಗದವರು ನೀಡಿರುವ ಸರ್ವೆ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಖಾಲಿ ಕಟ್ಟಡವಿರುವ ಪ್ರದೇಶದಲ್ಲಿ 4 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು ಗುರುತಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸದರಿ 4 ಗುಂಟೆಗಳ ಪ್ರದೇಶವನ್ನು ಯಥಾವತ್ತಾಗಿ ಕಾಲಿರಿಸಬೇಕೆಂಬ ಅಂಶದ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯಿಂದ ಅಭಿಪ್ರಾಯ ಪಡೆದು ಸಲ್ಲಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಹಾಲಿ ನಿರ್ಮಿಸಿರುವ ಕಟ್ಟಡಗಳಲ್ಲಿ ವಸತಿ ಕಟ್ಟಡದಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ಅವರಿಂದ ಮಾರ್ಪಡಿತ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆಗೆ ಸಂಬಂಧಿಸಿದ ಒಪ್ಪಿಗೆ ಪತ್ರ ಪಡೆದು ಸಲ್ಲಿಸಬೇಕಾಗಿರುತ್ತದೆ.
What was the direction issued, Mr. Sachin?
I know, sir, the direction is that if they submit a modified development plan, then we should consider the same.
If they are in accordance with the building bylaws.
Correct. I know, sir. Before that, my lord, there is one other endorsement also. I have not drawn my lord's attention to page number 8.
Yes.
Page 8.
Yes.
That is, the petitioner submitted the order of this court without submitting the plan, modified plan.
That is why we asked you, have you received? You just confirmed that you have received.
Subsequently, they have submitted it.
You have received Allah.
I have received it.
Adin ಏನು ಮಾಡಿದ್ರಿ?
ಅದಾದ್ಮೇಲೆ page 9 page 9.
Mr. Sachin.
Yes.
8, 9, 10, 18 ಬೇಡ.
Right.
Simple question is this. One page ಬನ್ನಿ.
Yes.
After you received it, this court directed them to submit and directed you to consider and pass orders in 2 weeks.
Yes.
When did you receive? What is the order you have passed? And when did you pass the order?
Yes. Well, so we have passed an order that is on 11/2/2020.
Page number?
Page 9.
9. ಏನಂತ ಹೇಳ್ತೀರಾ? ಹೇಳಿ.
ಪ್ರಸ್ತಾವನೆಯು RCB 95ರ ವಲಯದ ನಿಯಮಾವಳಿಗೆ ಅನುಗುಣವಾಗಿ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆ ಅನುಮೋದನೆಯಾಗಿದ್ದು ಅನ್ನು ಚಾಲ್ತಿಯಲ್ಲಿ ಇದ್ದ ಉದ್ಯಾನ ವನ ಬಯಲು ಜಾಗ -15% ಮತ್ತು CA -10% ವಿಸ್ತೀರ್ಣವನ್ನು ಕಾಯ್ದಿರಿಸಿ ಅದರಂತೆ 19/10/96 ನೋಂದಾಯಿತ ಪ್ರತ್ಯಾಜ್ಯತಾ ಪತ್ರದ ಮೂಲಕ ಹಸ್ತಾಂತರಿಸುತ್ತೀರಿ. ಹೀಗಾಗಿ RCDP 95ರ ವಲಯ ನಿಯಮಾವಳಿಗೆ ಅನುಗುಣವಾಗಿ ಮಾರ್ಪಡಿತ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆ ಸಲ್ಲಿಸುವಂತೆ ಹಾಗೂ ಉಲ್ಲೇಖ 2ರ ಪತ್ರದಲ್ಲಿ ಕೋರಿರುವ ದಾಖಲೆಗಳನ್ನು ಮಾಹಿತಿಯನ್ನು ಪ್ರಾಧಿಕಾರ ಸಲ್ಲಿಸಿದಲ್ಲಿ ತನ್ನ ಪ್ರಸ್ತಾವನೆ ನಿಯಮಾನುಸಾರ ಮುಂದಿನ ಕ್ರಮಗೊಳಿಸಲಾಗುವುದು. ಉಲ್ಲೇಖ 2 ಪ್ರಸ್ತಾವನೆ ಯಾವುದಿದೆ ಅಂದ್ರೆ page number that is
page number 8.
ಇದ್ರ ಪ್ರಕಾರ ದಾಖಲಾತಿ ಕೊಟ್ಟರೆ ನಾವು ಮಾಡ್ತೀವಿ. page 8 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ನೀವೇನೇನು ಹೇಳ್ತೀರಾ? ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿತ್ತು, ನೀವು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Court ultimately court has directed to submit the modified development plan and building plan without influencing the claim that is already submitted building plan. The modified development plan and building plan shall be in consonance with the constructed already put up. Said the development plan and building plan shall be considered by the court. If it found that building plan is not violating of the act or rules, the same shall be considered positive.
ಅಷ್ಟೇ. Why are you not doing that? Why are you not doing that? Plan sanction plan ಕೊಟ್ಟಿದಾರಲ್ಲಪ್ಪ ಮಾಡಿಫೈಡ್
whatever the site.
ನೀವು ಪ್ಲಾನ್ ಅಲ್ಲಿ CSI ತೋರಿಸಿಲ್ವಾ ಅವರು?
ಏನಾಗಿದೆ ಅಂದ್ರೆ there is a violation. That is the reason why the litigation is going on.
There may be a violation. This court said, including the violations, give it as it is. As built drawings basically ಕೇಳಿರೋದು. Have you given the as built drawings, Mr. Shetty?
Yes, my lord. Can I order sheet page 110 for a moment?
Where is that plan now?
It is with the.
Have you produced it before this court?
No, my lord. I can produce it, my lord. In fact, just for a moment, I'm sorry.
After they give it, If it is violated, you can reject by saying that these are the violations. But you are not doing that. You are saying, give me this, give me that. Adella itra violation. Admittedly, there are violations.
No, can I request my lords to turn to page 110 of the order sheet of this honorable court? Just for a moment. I'm sorry, my lord. Just for a moment. Yes. Order sheet, my lord, 110.
Handing over the CA site identified in favor of the BDA.
No, previous paragraph, my lord. Today, so assistant executive BDA who was present before the court submit that in compliance with the oral direction of they have inspected the building and construction put up are within the permissible FAR. It is not in dispute that the total extent of land measuring 35 acres and alternatives have also been identified. Learned consultation that the petitioner has no hesitation handing over relinquishment did. My lord, everything has been done. Only thing, my lord, I have submitted the modified plan.
You will explain to your commissioner, or we should explain it to your commissioner?
In fact, commissioner was directed to be present, my lord.
The order is clear. The basic minimum thing any authority would have to do is to comply with the orders. We don't want to call anybody. But we assume that you have explained and instructed properly. If your explanation and instructions are not accepted by the authority, then we'll have to ask the authority to come here.
No, my lord, fix the date for the next date of hearing for next week. I'll come back.
Please explain to them what is it, what they are supposed to do. If you have to do it in writing, so that it is placed before us. There's no point. The order sheet is bigger than many files. Why should it be pending? Alva? You might Muxi. 2013 might.
$1,800 families are residing in this property.
Sachin BS, the council appearing for the BDA submits that the memo dated 4/4/2022 is in compliance with the order dated 29/2019. A perusal of the our Shri Shashikaran Shetty and Senior Counsel submit that there is no compliance. Inasmuch as along with the said memo, there are various letters which have been produced calling upon the petitioner to produce certain and further documents, which is not the intent and purport of the order dated 29/2019 passed by this court. By referring to the various paragraphs of the said order, more particularly the penultimate paragraph, we submit that the petitioners were required to submit a modified development plan and building plan as per the construction already put up, and it was for the respondent board to ascertain if the said modified development plan and building plan is in accordance with the applicable building bylaws or not, and thereafter pass necessary orders as expeditiously as possible within a period of 4 months. He submits that though, when did you submit the plans, Mr. Shetty?
Within the period of 4 months,
date, please.
One thing, I'll just. I'm sorry, offhand, my apologies.
I'll seal Irvakala.
I'll call.
Mr. Sachin? Nimatra idea date.
Where is the date?
Submit that the said modified development plan and building plan was submitted on 25/11/2019, and as such necessary orders that we passed by 22nd March 2020, which has not been done. Shri B.S. Sachin, Learned Counsel appearing for the BTA, though admits the receipt of the development plan and building plan, he submits that there are further documents which are required and as such they were sought for. They not having been furnished, the BT has not passed necessary orders. I am unable to accept the said submission of Shri B.S. Sachin, Learned Counsel for the respondent, inasmuch as the penultimate para of the order dated 29/2019 passed by this court clearly indicates that it is only the modified development plan and building plan which are required to be submitted, which are to be examined by the concerned at the Bangalore Development Authority to ascertain if the modified development plan and building plan is in terms of and in compliance of the applicable rules and regulations. Faced with the above situation, Shri B.S. Sachin seeks for and is granted a week's time to report compliance with the order dated 29/2019, released on 31/5/2022. It seeks for 10 days time to comply, released on 7/6/2022.
Please, ma'am. Earlier memo of retirement filed by Sri Ravi B. Naik. Memo of retirement filed by Sri Ravi Naik is accepted. Memo of retirement filed by Sri Virana Tilvi is accepted. Yes, Mr. Manjunath? Yes. Who is appearing for the response? 27. I have 1 of 17. Objections are not article. Petitioner has filed IA number 1 of 17 seeking for amendment of the petition on 21/3/2017, which has been served on the counsel for respondent on 21/3/2017. Despite such service nearly 5 years ago, more than 5 years ago, no objections have been filed by the respondent, and today there is no representation on part of the respondents. I perused the application in IA 1 of 2017. By way of the said application, the petitioner intends to bring on record certain orders passed in related proceedings, as well as certain facts on record, being of the considered opinion that the said amendments are required for properly and effectively adjudicating the dispute. The said IA number 1 of 2017 is allowed. Counsel for the petitioner is permitted to amend the petition, file amended writ petition, and serve a copy thereof. After serving a copy thereof on the counsel for the respondents, all the above to be complied on or before 17/6/2022, 16/6/2022, released on 21/6/2022. Since Mr. Vivekanand and Anthony Brito has entered appearance for the petitioner, registry direct delete the name of Sri S. Shekhar Shetty as that appearing for the petitioner. Yes, Mr. Brito. Yes. It can be taken up for disposal along with it. Any objection? Consider it. Ready? Ella ready agi.
all, especially until 2015. We should not say that we have matters prior to 2015 pending in the High Court of Karnataka. We should not say that we have matters prior to 2015 pending in the High Court of Karnataka. Even 2015 is a problem, but at least Allik shuru stop matter. This is the first time bandavardella time. Next time don't ask. 28 at the request of Shri Brito, relist on 31/5 776 76. Shri Mr. Shravan S. Lokre has entered appearance for the petitioner. Registry direct delete the name of Shri A.S. Mahesha. Is that appearing for the petitioner? What is the amendment? To show discrimination, huh? Any objections? Consider the petitioner has filed IA number 1 of 2022 seeking for amendment of the petition to bring certain additional facts as also an additional prayer on record. There being no objection on part of the counsel for the respondent, said IA number 1 of 2022 is allowed. Counsel for the petitioner is granted a week's time to carry out necessary amendment and file amended petition. The petitioner then why did you escape from it?
Then it got declubbed because the prayer was for issuance of receipt award, and there was no specific prayer made for allotment of site.
We'll have it on 31st. You file this because that prayer has to be entered in CIS. Amele nimma final order al baralla. Relist on 31/5. Before that, you file it.
I prefer the petition. I prefer the petition. I have filed this application.
Yes, Mr. Bhatt, we can't see you and we can't hear you very well.
No, I'm here. I'm here.
Additional district registrar.
Yes, there are two documents that I want to produce. The certified copy of the order sheet in 2 suits and the plain copies.
Additional district registrar, you'll take notice. And AG accepts notice for respond number 2 also. Registry is right, print the name of the AGA as that appearing for respond number 2, 3, and 4. Yes, ready, Mr. Top? Ready? Yes, Mr. But on merits.
On merits, may I request your lordship to have it next week, Milord? Sorry. Sorry. Sorry.
Lakshmi Sharu,
first or second, not on 31st.
ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಮಾಡುತ್ತಾರೆ ಬಂದ್ರೆ ಕೇಳೋದು ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. Though the counsel for the petitioner is present and ready to address arguments, none appears for the contesting respondent number 7. Relist on 7/6/2022. It was made clear that if on that day none were to appear for respondent number 7, the matter would be taken up for consideration thereafter.
May be considered along with the main.
Yes.
Please.
IA number 1 of 2022 shall be considered along with the main arguments.
Please.
To BDN. ಅದರ ಮೇಲೆ ಹೊಡೆದ R2 district register attached to BDN. Who is that? How can a register be attached to? Who is this? Who is this, Mr. Butt? Respond number 2. ಹೆಂಗೆ ಮಿಸ್ಟರ್ ಲಕ್ಷ್ಮೀಶ್, ನೀವೇ ಒಂದು ಸಬ್ ರಿಜಿಸ್ಟರ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? ಅಷ್ಟೇ, ನೀವೇ ಹಾಕ್ತೀರಾ? ನೀವೇ ಹಾಕ್ತೀರಾ? ಒಂದು ಸಬ್ ರಿಜಿಸ್ಟರ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಅವ್ರ ಆಫೀಸಲ್ಲಿ ಮುಗೀತ್ ಕತೆ. You have to carry out amendment. Who is appearing for 10 and 11 now? Lakshmesh Rao 2 to 9. Munna Jagdishwara 10 and 11. Shankar Nayan Rao 10 and 11. Current counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment. Relist on 7/6. The AGA accepts notice for respond number 3. Since H. Devendrappa has entered appearance for respond number 4, registry direct delete the name of IG Gachinmat as that appearing for respond number 4. In paper publication, hence memo of retirement filed by IG Gachinmat is accepted. Who is respond number 5? 5 times agide. You can take paper publication. R5. Firstly, we are on R5. Who is R5? Who is R5? I told you. Current counsel for the petitioner seeks for and is granted a week's time to file necessary application for subservice in respect of respond number 5. Proposed yaro. That is IA 1 of 16. So we'll pass orders on IA 1 of 16 and this on the same date instead of 2 dates. Returnable date problem. Relist on file your application, favorable application. Order relist on 7/6. New application haki avattu notice plus the application. Registry is direct to delete the name of Shri K. Suman as that appearing for the petitioner and instead print the name of Shri Siddharth Suman as that appearing for the petitioner. Since Shri Devendrappa has entered appearance for respond number 7 and 8, registry is direct to delete the name of Shri IG Gachinmat as that appearing for respond number 7 and 8. Devendrappa, you are appearing as also Mr. Ramajne Gowda as that appearing for respond number 7 and 8. Yes. Memo of retirement filed by Shri IG Gachinmat is accepted. IA 1 of 17 has been filed for early hearing. IA 1 of 22 has been filed for posting of the matter. Both the applications are allowed. Relist on tomorrow 31. Very Tuesday. B day is only on Tuesday. 31/5. Relist on 31/5 for final hearing. Since Shri B.N. Prakash has entered appearance for the petitioner, registry is directed to delete the name of Shri S. Shekhar Shetty and A. Anil Kumar as that appearing for the petitioner. Shri B.N. Prakash seeks for and is granted a week's time to comply with office objections. Objections hakidira? Since the pleadings are complete, relist on 7/6/2022 for final hearing. Yes.
So petition will be connected along with the WP number 20827 of 2019.
You have filed your objections?
Yes, that matter I filed my objection. Very short point. Now allotted a site here.
So you'll adopt that objections here also?
Yes.
Is what you are saying?
Due to there is a Nala which is running the site. Now the subject matter is adjacent to the site, the subject matter is better.
Shri B.S. Sachin, Learned Counsel,
How
sir.
you know that fact?
Shri B.S. Sachin.
Allot an alternative site in that.
So same in law.
Same.
Shri B.S. Sachin, Learned Counsel for the respondent, submits that the above matter is connected to WP number 20847 of 2019, and hence he requests for the same to be connected. He submits that objections have been filed, statement of objections has been filed in that matter, which you would be adopting in the present matter. An affidavit has been filed in that matter, which would equally apply to the present case also. Taking the above submissions into consideration, IA-1 of 2022 for posting is allowed. Relist on 31/5 for final hearing. Interim order earlier granted is extended to next date of hearing.
Yes, my lord, the notice was issued, my lord, to the proposed respondent. Notice has been served, my lord. And proposed respondent notice was issued, my lord, and they have been served. If not, if they have any objections, my lord, let them file it. Otherwise, you lordship may allow, my lord.
They have filed objections. File
No, copy kottilla.
Yavat file. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಕ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ. ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ನೀವೆರಡೂ ಹೇಳಂಗಿಲ್ಲ ಅಲ್ವಾ. ಶ್ರೀ V. Krishnamurthy, Learned Counsel, who appears for the proposed respondent, seeks for and is granted a week's time to file his objections to IA-1 of 2022, being a pleading application. Objections, if any, to be filed on or before 2/6/2022, relist on 7/6/2022.
Bless me.
Why is Morar have taken off notice on second respondent?
Who is the second respondent? Who? Private party?
He is a private party. He has appeared before this court on the contempt side. But nonetheless, he is not still.
Who appears for him in that contempt?
Senior counsel appears.
Who is? You can't issue notice. Then we can't help you. We can't.
I do understand.
You'll have to come after.
I'll verify that.
Andre samast steps togoli.
It has been served or intimation delivered. Neither arguing that is. I'll have to.
Furnishing of FPF antide. You process fee kottilla anta ಹೇಳ್ತಾರೆ.
Definitely have given. This is for the third time it is coming.
Item discussed on 20th March 2021. Postcard flagship does not disclose any details.
ಇನ್ನೇನು ಡೀಟೇಲ್ಸ್ ಸಿಗಲ್ಲ. 3 months ಅಷ್ಟೇ. Counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee and furnishing copies to service of notice on respond number 2. If the process fee and copies are furnished, registry is directed to issue notice to respond number 2 returnable by 29/6/2022. Registry is also directed to put out the postal track record on that date. Relist on 20. So 29/6. Yes. You are ready for again. File ಮಾಡಿಲ್ವಾ? ಯಾಕೆ? You have filed objection. ನೀವು ಯಾರಿಗೆ? You have prepared the objection.
There is order of this honorable court. The respondent has to submit the written
order sheet. ಯಾವತ್ತು ಡೇಟ್? 1333. What are you saying by referring to this order? What is your submission? Where does it say that? Where does it say that in the order? Where does it say in that order? The order only says is secure instructions, file his objection. ಎಲ್ಲಿದೆ ಓದಿ? ಅದೇನಪ್ಪ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಅವ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡ್ತಾರೆ, ಇವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿದ್ರಿ? ಅವ್ರ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ವಾ ನೀವು? ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ, 13(4) it has been filed. Your acknowledgement is there. Advocate for petitioner acknowledgement ಇದೆ. ಸೊ ಇದು ಬಿಟ್ಟು ಇನ್ನೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳೋಣ. So your file. Now this objection has been signed by whom? Has been signed by Deputy Commissioner. So that will comply with your order. Correct? Sir, you have ಕೊಡ್ತೀನಿ ಅಂತ ಕೊಡ್ರಿ, ಅಲ್ಲೇ ಕೊಡ್ರಿ ಒಂದು ಕಾಪಿ. ಇರ್ಬೇಕಲ್ಲ ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ. ಸಿಕ್ತಾ? ನಿಮ್ದೇನಪ್ಪ? ಯು ಫೈಲ್ಡ್ ಫೈಲಿಂಗ್ ಅಲ್ಲೇ ಇದೆ, 1 week ಏನ? 1 week ಸೈನ್ ಮಾಡಕ್ಕೆ ಏನಕ್ಕೆ? ಇಲ್ಲ, ಯು ಫೈಲ್ಡ್. ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿ? ಯಾವ್ದು ಮಾಡ್ತೀರಾ? ಹಂಗೆಲ್ಲ ಟೈಮ್ ಕೊಡಲ್ಲ. ಇಲ್ಲ ಅಂದ್ರೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟೇ. Learned AGA submit that he has filed a further statement of objections, this time signed by the Deputy Commissioner, as directed by this court by order dated 30/3/2022. Shri Manjunath AC, Learned Counsel, appearing for respond number 6. Respond number 6. 2 now. On behalf of Srimati Sumana Baliga, appearing for respond number 4, an adjournment is sought for to file statement of objections. Shri M.S. Devaraju, Learned Counsel, for respond number 9 and 10, submit that his objections are ready, and as soon as the same is signed, it will be filed. Counsel for respond number 4, 9, and 10 are directed to file their objections on or before 2/6/2022. If no objections are filed by that date, objection will be taken as not filed. Relist on 7/6/2022.
Lords, I appear for the petitioner, my lords. My lords, in this, my learned friend Mr. Vachan is to file his statement, my lords.
Vachan? Who is appearing, Mr. Vachan or Mr. Ganapati Agde?
Mr. Vachan is appearing for the BDA, my lords.
PK Shrikara and Ganapati Agde? Ibru second respondent. R2 ಅಂತಿದೆ ಅಲ್ಲಿ. First list ಅಲ್ಲಿ. Shri B. Vachan has entered appearance for respondent number 1. Then the registry is directed to delete the name of Shri K. Krishna as that appearing for respondent number 1. As also correct the appearance of Shri B. Vachan as that for respondent number 1. Registry is directed to delete the name of Shri Ganapati Agde as that appearing for respondent number 2 and only retain the name of Shri P.K. Shrikara as that appearing for respondent number 2. Yes, Mr. Vachan, you have to file objections.
Yes, Lord.
Early hearing allowed. Statement of objection to the main name. Yavaga. You entered appearance in January 22. So now we heard it in May 2022. Therefore, we'll pass judgment in December 2022. We'll direct in all matters, Mr. Vachan. In all matters, you have to file.
The litigation about the respondent or petitioner association respondent developer with respect to the road to fix the BDA. The respondent number 2 TDS respondent number 2 private parties to claim a right over the commercial property in which is carrying out the construction. They are filed their objection. They will be kindly directed to give a copy of the objection.
Oh, respondent number. You are appearing for respondent number.
I am appearing for respondent number 2. And there's a 9-meter wide road that has been sanctioned by the BDA. And I have obtained and produced an initial report from the report of a surveyor who confirms that the entire stretch of the road, even today, has not been shortened. It remains 9 meters. What I have done is I have only put the fencing on the edge of the 9 meter to give more protection to the property. I'm not saying it's a.
You have filed your objections.
I filed my objections. I filed the survey report. In fact, BDA has
very short role, Mr.
Otherwise,
You only have to say whether it exists or not. You only have to say whether that road exists or not. What is my dimension? ಅವರಿಬ್ರು ಜಗಳ ಆಡ್ಕೊಳ್ಳಿ ನೀವು ಮಧ್ಯದಲ್ಲಿ. Your relief basically is, what is your relief, Mr. Joseph?
Lords, I am seeking a mandamus, my lords. I have sought. I am quite certain, my lords. Of course, it is.
No construction. Ensure no construction. Perform no construction.
Please, my lords. If my lords, the BDA will have to report, my lords. If it is a 9-meter road and there is construction on it, there ends the matter, my lords.
Shri B. Vachan, learned counsel appearing for respondent number 1, seeks for and is granted 2 weeks time to file his objections. Objections, if any, to be filed on or before 16/6/2022. Relist on 21/6.
I'm obliged, my lords.
The request of the counsel for the petitioner, relist on 31/5. What is it that you want in this? Well, bega mukshi. Who had appeared in for respondent number 3? Shri Girish Kodgi is directed to accept notice for respondent number 3. R2 Gyaro. C. Ramaya is directed to accept notice for respondent number 2. R1 served. Since respondent number 1 had earlier been served and was unrepresented, notice to respondent number 1 is dispensed with. The last line of that. Relist on put the registry is directed to put up the file in MFA number 6105 of 2011 and relist on 9/6. LA ಅಂದ್ರೆ ವಿಡಿಯೋ ಜೊತೆ ವಿಡಿಯೋ ಕೌನ್ಸಿಲ್ ಇರ್ತಾರೆ. You are appearing for respond number 2 and 3. Yes. Statement of which when will you file your objections, Mr. University? 2015 matter. If you are not receiving parawise remarks, we'll ask your commissioner to be present. To appraise him, that is, representatives are not receiving parawise. 7 ವರ್ಷ ಬೇಕಾ 2015 matter. ಇನ್ನ parawise comments ಬರಲಿಲ್ಲ. Shall we make a note of your submission that you have not received parawise comments till now? To help you out, shall we make a note that councils are not receiving parawise comments so that. And do you have any litigation management system in BDA to keep track of the litigation? ಯಾವ stage ಏನಿದೆ, ಯಾವಾಗ parawise comments ಕೇಳಿದ್ರು, ಯಾವಾಗ ಹೋಯಿತು, ಏನಾದ್ರು ಇದೆಯಾ? For now, we'll direct you to keep your head of legal present for BDA. So this kind of things we can sort of. We'll give you time, but we'll also have to streamline this thing. Otherwise, ಎಲ್ಲದರಲ್ಲೂ ಹಿಂಗೆ ಹೋಗ್ತಾ ಇದೆ. ಅದು ಆರ್ಡರ್ಸ್ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಬೇರೆ. ಈ ಗ್ರೂಪ್ ಬಂದ ಮೇಲೂ ನೀವು ಕೇಳಬೇಕು ಅಂದ್ರೆ ಇಟ್ ಬಿ ಡಿಫಿಕಲ್ಟ್. 2 weeks ಕೊಡ್ತೀವಿ ಅದು ಅವತ್ತು keep your head of legal present. Though the matter is of the learned counsel for respondent number 2 and 3 seeks for a short accommodation to file his objections. Though the said request need not be accepted by this court, considering that the matter is of the year 2015, in the interest of justice, one more opportunity is granted. Objections, if any, to be filed on or before 10/6/2022. The learned counsel for respondent number 2 and 3 is also directed to keep the head of legal, Bangalore Development Authority, present before this court on 14/6/2022 with a status report as regards the litigation management system adopted by the BDA to keep track of the litigation against BDA, the dates on which objections have to be filed, the dates on which the paravised comments have been sent, the dates on which the objection statement are filed, etc. That is to keep track of the workflow involved in litigation. Relist on 14/6.
I prefer the respond number 7.
And AGA accepts notice for respond number 4, 5, and 6. 3 arrow. 3 to 6. Who appears for the petitioner? Mr. Shiv Prakash. What is this, Mr. Krishna? Public interest litigation, are they? Hello, Mr. Devendra. Colleague. None appears for the petitioner. Relist on 31/5. ಯಾರಿಗೆ ಕೃಷ್ಣ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ ಕೊಡಿ ಕಾಪಿ ಅವ್ರ ಹತ್ರ ಒಂದು ಕಾಪಿ ತಗೋ Nurgesh Charati has entered appearance for respondent number 1 and 2. Registry is directed delete the name of Shri C.R. Gopal Swami is that appearing for respondent number 1 and 2. Srimati Sumangala Simant has entered appearance for respondent number 5. Registry is directed delete the name of Shri I.G. Gachammat is that appearing for respondent number 5. So 1, 2, 3, 4, 5. Yes. This much more bigger. Ready? Madam? ಆಗ್ಲೇ ಇದ್ರಲ್ರಿ ಇವತ್ತ ನೆನ್ನೆ ಇದ್ರಲ್ಲ Though the counsel for the petitioner is present and ready to address his arguments, short accommodation is sought for on behalf of respondent number 1 and 2. We list on 31/5. Now R1 and 2. Shri Sachin BS accepts notice for respond number 2. Since he has already appeared for respond number 1. As such, registry is directed to delete the name of Shri Vikram Aditya Oilgol as that appearing for respond number 1 and 2. Very Ibran Ayrada. As also the name of Shri Vinay Devraj as that appearing for respondents. Where is Mr. Sachin? Objections? Where are? Already filed. Agidya? Copy ಕೊಟ್ಟಿಲ್ವಾ? ನೀವು ಏನೋ ಕೊಡ್ತೀರಾ? Shri Nishan Devi, the council submit that he has not yet received a copy of the statement of objections filed by respond number 1 and 2. Respond number 1 and 2 undertakes to furnish the same by end of the day today. We list on 2016. We list on 7/6. Interim order granted earlier is extended till next date of hearing. ಏನಕ್ಕೆ? ಯಾವುದ್ರಲ್ಲಿ? 2016. ಒಂದರಲ್ಲಿ ಆರ್ಡರ್ ಆಯ್ತು, ಇದ್ರಲ್ಲೂ ಅದೇ ಆರ್ಡರ್. 6 years for filing objections. Also, ಅದಾಗಿದೆಯಾ? ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಸಚಿನ್ ಎಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ? We'll have it in the afternoon. 31st. At the request of Shri B.S. Sachin, we list on 31/5.
49.
ಯಾರಾದ್ರೂ ರೆಡಿ ಹೇಳ್ರಿ, ಇನ್ನ ವೆಕೇಶನ್ ಮೂಡಲ್ಲೇ ಇದ್ದೀರಾ? ಲಕ್ಷ್ಮೀಶ್ ರೆಡಿನಾ? ನೋಡಿ ಅವ್ರು ರೆಡಿ. 49 at the request of the council for the petitioner released on 31. ರೆಡಿ ಆಗಿ ವೆಕೇಶನ್ ಆಗೋಯ್ತು. Objections file ಆಗಿದೆಯಾ? Very 3 dates, so they take 7 years. Years ಲೆಕ್ಕ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ, ಬರೀ ಡೇಟ್ ಲೆಕ್ಕ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. ಏನ್ ವಚನ ಇದೆ? ವೇಷನ್ ತಗೊಂಡಿಲ್ವಾ? Page number? Type copy of Annexure E ಇದೆಯಪ್ಪ, ಫೋಟೋ ಇಲ್ಲ. Award 78 Annexure F 78. ನೀವು ಪೇಜ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಯಾವ್ದೋ ಸೈಟ್ ಮುಂದೆ ನಿಂತಿದ್ದೀರಾ, ಆಮೇಲೆ ಯಾವ್ದೋ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ನಿಂತಿದ್ದೀರಾ. ಇದು ಸೈಟ್, ಇದು ಯಾವ್ದೋ ಗ್ರೌಂಡ್. ಈ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು, ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿದೆ, ಶೆಡ್ಯೂಲ್ ಎಲ್ಲಿದೆ? 33 north to south. Okay, site. In disposes ಮಾಡಬೇಡಿ Mr. Vachan. Vachan, for whatever reason, you are in the hot seat now. ಎಲ್ಲದರಲ್ಲೂ ನೀವೇ ಫೈಲ್ ಮಾಡಬೇಕು. ಅಲ್ಲ, ನೀವು ಫೈಲ್ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್, ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಎರಡರಲ್ಲಿ ಒಂದು ಮಾಡಿ. ಯಾವಾಗ all your legal officers, make them sit and get it. So this cannot be pending for such a long time. Understand, but why does it take 6 years to give you the Paravise comments? 3 years to 3 years. Instructions ಆದ್ರೂ ಇರಬೇಕು. ಇವಾಗ ಎಲ್ಲ ಅಧ್ಯಯನ ಆಗ್ತಾ ಇದಾವೆ. ಏನ್ ಹೇಳಿ? ಏನಾಗಲ್ರಿ ಡಿಸ್ಪೊಸಿಷನ್ ಖಾಲಿ ಸೈಟ್ ಅವ್ರೇನ್ ಕಟ್ಟಲ್ಲ ಅದ್ರ ಮೇಲೆ. Shri B. Vachan, Learned Counsel for respondent number 2 and 3 seeks for and is granted 2 weeks time finally to file his objections. Objections, if any, to be filed on or before 9/6/2022 after serving a copy thereof in the counsel for the petitioner. Relist on 14/6. Mr. Harikrishna Holla. Objections ಹಾಕಿದ್ದೀರಾ? ಯಾವಾಗ ಹಾಕ್ತೀರಾ? None appears for the petitioner and counsel for the respondent seeks for and is granted 2 weeks time finally to file objection. Objections, if any, to be filed on or before 9/6/2022. Relist on 14/6/2022.
For the petition in this case, my lord, but I pray
Yes.
for a short petition, my lord. I shall inform the respondent also, my lord. Any days after 1 week, my lord.
Has the objections been filed, madam?
Oh, my lord.
No, my lord. I
Mr.
should not.
Krishnan,
My lord,
when
appearing
will you file, madam?
by the next date of hearing, it shall be filed.
Next date of hearing is tomorrow.
My lord, a week's time, my lord.
Next date and everybody, that will give us the discretion.
By
2 weeks.
much
55, same order.
Please.
We filed on 9/6, relist on 14/6. Yes, Mr. Monish, why only R2, R1 arrow? R1 BDN, huh? Where R1? Okay, R2 ಅಂತಿದ್ದಾರೆ. Cause list ಅಲ್ಲಿ R2 ಅಂತಿದ್ದಾರೆ. Registry is directed to correct the appearance of Shri Murugesh Vicharati as that appearing for respondent. So there is only one respondent. Objections. Next time ಕೇಳಬೇಡಿ ಹೇಳಿದೀವಿ. We will observe things. Same order. Finally, 9/6, 14/6, interim order earlier granted is extended till next day. One, two, three, 1, 2, 3. Also, under 230, na? All of you come at 2:30 without any confusion. Pass over 2:30. Mr. Prakash. Pass over. Where is he? Yes, Mr. Prakash. Mr. Chandrasekhar. ಆಗಲೇ ಇದ್ರೆ ಇಲ್ಲಿ ಪಾಸು ರೆಡಿನಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಆಗಿದೆಯಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಆಗಿದೆಯಾ? ಏನಿಲ್ವಾ ಅಬ್ಜೆಕ್ಷನ್? ಅಲೋ ಅಂತಾರ. ಪಾಸು
In serial number 60, my lords, I am not have instructions to appear for response 3 and 4. KIAD, yes. Lord, acquisition is under the KIAD Act. Objections are yet to be filed. My submission for the day is this, Lord. The petitioners have filed this writ petition in respect of 2 survey numbers, and my lord, the interim order is obtained against the entire, my lord, notification which relates to, my lord, more than 842 acres. For my respect to submission to your lordship is that the interim order may kindly be restricted to, my lord, to the lands, my lord, which are the subject matter of the writ petition.
So far as the petitioner is concerned and dictation ಮಾಡಿದ್ ಬಂದಿಲ್ಲ.
My lord, in the interim order, my lord, notification, entire notification.
ನೋಡ್ರಿ ಫ್ಲಾಪ್ ಇತ್ತು ಅಂದ್ರೆ ನಮ್ದೇ ಅಂತ ಗೊತ್ತಾಯ್ತು. In so far as petitioner is concerned and ಬಂದಿಲ್ಲ. Shri Basuraj Sabrat, learned counsel who appears, learned senior counsel, appearing on behalf of
3 and 4, my lord.
First ಅದು ಹೇಳ್ಬೇಕಲ್ಲ. Shri H.L. Pradeep Kumar has entered appearance for respondent number 3 and 4. And the registry is directed to delete the name of Shri P.V. Chandrasekhar as that appearing for respondent number 3 and 4 and instead print the name of Shri H.L. Pradeep Kumar as that appearing for respondent number 3 and 4. Shri Basuraj Sabrat, learned senior counsel, appearing on behalf of Shri H.L. Pradeep Kumar, submits that while order dated 28/4/2022, the entire acquisition notification has been stayed and therefore orally makes a request for modification of the said order so as to restrict it to the benefit of the petitioner alone. The counsel for the petitioner has no objection for the same. As such, the notification dated 11/8/2020, as such the interim order dated 28/4/2022 is modified and shall read as under. The notification dated 11/8/2021 at Annexure K and the notice dated 13/4/2022 at Annexure N is stayed till the next date of hearing only insofar as the petitioner is concerned. Correct. Petitioners lands. Petitioners and petitioners lands are concerned. Correct. Shri Basuraj Sabrat seeks for and is granted 2 weeks' time to file objections.
Yes, please.
Objections, if any, to be filed on or before 9/6/2022, released on 15/6/2022.
Obliged.
Are we? ಅವಸರ ಮಾಡಲ್ಲ.
I represent the contesting respondents.
ಯಾರ ಅಗೇನ್ಸ್ಟ್ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವರೇ ಇಲ್ಲ. ಅರವಿ ಅವ್ರು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. Idra illena result. So the counsels for the respondents are present, none appears for the petitioner, and relist on 31-5.
Grateful.
$62.
Lord, I appear on behalf of respondent number 4 to 8, Lord.
4 to 8.
I appear for the petitioner. This is a matter pertaining to the.
Mr. Sebastian, you appear for the petitioner.
Yes,
so Mr. Ravi Prakash's name has to go.
Yes, ma'am.
Lord.
Padri Vishal for 4 to 9, and Ravindranath Kamat's name has to go. What about Shevgur and Kamat Associates? Who are they appearing for? What do you cost?
My lord, appearing for R2, my lord.
R2.
BDA, my lord.
Four to 8 on the movie. M.A. Sebastian has entered appearance for the petitioner, and registry directed delete the name of Sri Ravi Prakash is that appearing for the petitioner. Sri H. Srinivas Rao has entered appearance for respondent number 4 to 8, and registry is directed delete the name of Sri N. Ravindranath Kamath, as also Mr. Shevgur and Kamath Law Associates, as that appearing for respondent number 4. Yes, Mr. Sebastian, ready?
Yes, my lord.
Lord, I appear for respondent 4 to 8, Lord. I have some personal inconvenience today, my Lord. I request a short date, my Lord.
Though the learned counsel for the petitioner is present and ready to address his arguments, counsel for respondent number 2 and 4 to 8 seek for a short accommodation. Relist on 31/5/2022. All the counsels are directed to file their respective synopsis, list of dates and events, and list of authorities after exchanging with each other before the next date of hearing.
In that case, a little 2 weeks time may be given because to make the synopsis.
7/6.
Much of
List on 7/6.
Much of it.
63.
My lords, I appear for R2 in this matter in 63. In fact, the petitioner's counsel is Senior Advocate Mrs. Pramila Nesargi, and this matter pertains to a civic amenity site which we are saying should be maintained as a park. Now, my lords, actually petitioner and us have agreed. Even the petitioner agrees that it can be kept as a park. Petitioner was the original allottee. We just want to ensure that BDA also is agreeable to this. If 2 weeks time could be granted, it could be kept on 7th June. Hopefully even BDA will agree. And this plot can be maintained as a park. That's all ultimately that we want. In fact, petitioner is also agreeable that I had a word with, on the last date also it was written as report settlement because...
So you file a affidavit or a joint memo?
We'll do that. Our only concern is BDA should not say, no, we won't keep it as a park. We are a residence group.
Get BDA also to sign it.
We want to do that.
To
we want to do that, my lords. We'll try to do that. If this could be given 2 weeks time, maybe on 7th.
2011 matter, madam. Either you do that or address arguments on the next
I agree. I agree. My lords, I agree.
Don't seek for an adjournment on the next date.
Very well, my lords. I agree. Totally.
The Jaina Kothari, learned senior counsel appearing for respondent number 2, seeks for and is granted 2 weeks time finally to file a settlement document, since she submits that the settlement has been arrived at. Relist on 14/6/2022. Considering that the matter is of the year 2011, it is made clear that no further adjournment would be granted. If a settlement document is not filed on that date, all the counsels are directed to be ready to address arguments in the matter.
Great.
Sri ನೀವು ಯಾರಿಗೆ R2 ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಾ? He was appearing for R1. Who was he appearing for?
BDA, I think.
Since Sri Unni Krishnan M has entered appearance for respondent number 1, registry is directed to delete the name of Sri Vipin Negide, Sri Ravi G. Shabai, and Sri VY Kumar and associates as that appearing for respondent number 1. Since Sri Rohan Kotari has entered appearance for respondent number 2, registry is directed to delete the name of Srimati Jaina Kotari as that appearing for respondent number 2. We list on 14/6.
Grateful, my lords. Much.
I appear for petition, my lord.
Yes, Mr. Janardhan.
This is second round of litigation. In the earlier round of litigation,
Ready na, Mr. Janardhan.
dispose ಮಾಡಬಹುದು ಇದನ್ನ ತಾವು ಪ್ಯಾರಾ 6 of the objection statement ನೋಡಿದ್ರೆ
ಯಾರ ರೆಡಿ ಅಂದ್ರೆ ನೀವು ರೆಡಿನಾ?
ಪ್ಯಾರಾ 6 of the objection statement ಒಂದ್ಸರಿ
ಒಂದ್ ನಿಮಿಷ ಜನಾರ್ದನ್ ಏನೋ ಹೇಳ್ತಾರೆ ಕೃಷ್ಣ.
ಆಯ್ತು,
ನೀವು ಮೈಕಲ್ ಮಾತಾಡೋ ಅವ್ರು ಕೇಳಿಸು. ಆನ್ ಮಾಡಿ, ಆನ್ ಮಾಡಿ. ರೆಡ್ ಲೈಟ್ ಬಂತ, ವಾಲ್ಯೂಮ್ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕು, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಜನಾರ್ದನ್?
yes madam, I am hearing. Madam, yes, I am hearing.
It is for additional land, we have notified the land by certain lands.
ನಿನ್ನೆ ಹೇಳಿದ್ರು.
Thereafter, that additional land of this is a separate notification. After 2010, 2011.
Like original land, additional land ಇದು.
It is additional land. Additional land 2011 ಅಲ್ಲಿ notify ಮಾಡಿದ್ರು. ಆನಂತರ ಅದನ್ನು since the Supreme Court said that you first follow the medical report, then you notify that. ಆನಂತರ ಇದನ್ನು they will not continue. Now, for additional land is concerned, some they are issuing a fresh notification. For that, I will seek the.
ಇದು ಹೋಗುತ್ತೆ, ನೀವು ಫ್ರೆಶ್ ನೋಟಿಫಿಕೇಶನ್ ಬಂದ್ಮೇಲೆ ಮಿಸ್ಟರ್ ಜನಾರ್ದನ್ will again come back with the third one.
Para 6 objection statement ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ. Para 6, your lordship may read that. Para 6 of the objection statement.
Mr. Krishna wants he wants some clarification to make a submission with authority.
What he no, your lordship can grant it, no objection. But what he made it clear in the para 6 is, at present he said if any additional requirement of land, he will notify. So at present he is not proceeding. That is what the statement. That if that is so, it could be disposed of.
ಅದೇ ಬಂದು ಹೇಳ್ತಾರೆ, ಪ್ರಾಬ್ಲಿ ಅವತ್ತು ನೋಟಿಫಿಕೇಶನ್ ತಗೊಂಡ್ ಬಂದು ಹೇಳ್ಬೋದು.
ಆಯ್ತಾ,
ನೋಟಿಫಿಕೇಶನ್ ತಗೊಂಡ್ ಬಂದ್ರೇನು ಆಗ್ಲೇಬೇಕು.
ಇದನ್ನು ನೋಟಿಫೈ ಮಾಡ್ತಾರೆ ರಿಕ್ವೈರ್ಡ್ ಅಂತ.
At the request of Sri K. Krishna, learned counsel appearing for respondent number 1, relist on 7/6.
One submission. Yesterday, your lordship party clarification that the scheme has been approved. ಅದರಲ್ಲಿ ಇದೆ page 7.
ಅದರಲ್ಲೂ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ, ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ, ನಾನು ಫೈಂಡ್ ಔಟ್ ಮಾಡಿಲ್ಲ.
2007 ನೋಟಿಫಿಕೇಶನ್ ಮುಂಚೆ ಸ್ಕೀಮ್ ಇತ್ತ.
2007 ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಮೆನ್ಷನ್ಡ್ ದಟ್ ಸೊ ನಂಬರ್ ಅಲ್ಲ ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್
ಅಲ್ಲ, ಅದು ನಂಬರ್ ಇತ್ತು ನೆನ್ನೆನು, ಬಟ್ ಅದು ಆರ್ಡರ್ ಬೇಕು.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್,
ಕ್ಲಾರಿಫಿಕೇಶನ್ ನಾನು ಫೈಂಡ್ ಔಟ್ ಮಾಡಿಲ್ಲ.
ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ನೋಡೋಣ.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಯಾರು? ಹೂ ಇಸ್ ದ ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್? R2 ಯಾರು?
DDA supported the petitioner's case in 86, then after subsequently to favor the former CM and the PS college, I made all these things in the submissions. Now the objection.
ಹೇಳಿ. petitioner's trust. ನಿಮ್ಮ ಟ್ರಸ್ಟ್ ಇಂದ ತಗೊಂಡು ಆ ಟ್ರಸ್ಟ್ ಕೊಟ್ಟರು ಅಂತೀರಾ?
ಸಪೋರ್ಟ್ ಮಾಡೋದು BDA ರಿಪಿಟಿಷನ್ DAL ಈಗ ನಾವು ಅಲ್ಲಿ ಸೈಟ್ ಅಲ್ಲಿ ಏನು ಮಾಡಿಲ್ಲ ಹಸು ಯಾಕೋ ಇದು ಮಾಡ್ತಿದ್ದೀವಿ ಅಂತ they gave a unfavorable statement and BDA acquired the property back.
ಅಲ್ಲ, any order that is to be passed in this matter will affect respondent number 2.
Yes, the last time a suggestion was made to BDA. This petitioner was maybe given some alternate site, which are this site only still CA site which is still there, which is allotted in the year 1977 to them. They constructed a building till nickel level. That was supported by the same BDA before this also in PA.
Alternate land ಕೊಡ್ತೀರಾ?
This was cancelled because they have not utilized the land for the purpose for which it was issued. And this was honorable court in the earlier petition appointed the court commissioner. And
Hello, why we asking you that is alternate land ಕೊಡಂಗಿದ್ರೆ respondent number 2 ಬೇಕಾಗಿಲ್ಲ.
ಅವರು ರಿಟರ್ನ್ ಮಾಡಿದ ನಂತರ it was allotted to the BKP for the health center.
So even respondent number 2 is not in occupation of that land.
No,
petitioner's land.
The problem is several PA came. They brought out the light how this land was taken away by the.
Let us understand this whether R2 ಇವಾಗ ಇಲ್ಲ. ಅದಕ್ಕೆ let us understand whether they are required or not. Number 1 ನೀವು ಹೇಳಿದ್ದು they have been allotted. Now it's been surrendered by R2 to BDA. So they are no longer in possession of the land. So they are not even a necessary party now. So now you are saying that you have allotted the land to BBMP. Then BBMP has to be made a party.
What I heard from the petitioner was now the BDA has allotted the land which would have directed.
Alternative amendment ಕೇಳಿದ್ದೀರಾ? Amendment ಆಗಿದೆಯಾ?
Amendment regarding the petitioner expired and
your prayer continues to be reconvey the trust property from the.
Yes, yeah. That stands still. I stand by this.
So now if it has been allotted to BBMP,
because during the pendency of the petition, they cannot do that. And moreover, whatever them.
You have to ask for relief.
Your Lordship, in the year 1986, in the petition number 10642 of 1986, a public interest litigation was filed against.
It's not today.
False submission amounts to perjury. When a submission what BDA made in 1986, now they are telling how to be different. And
Mr. Ramananda, please understand what he is saying. He is saying that it was allotted to respondent number 2. Respondent number 2 has returned the land. Thereafter, the land has been allotted to BBMP, who has constructed a health center. So if that is the case, without BBMP being a party, even if you succeed, then you won't get any benefit.
First, the court made a gracious submission. I'll just make a few submissions. Lordship, I'll make certain prayer amending the prayer if it is being allowed.
Argument Madi. Why do you want to argue till then?
In the case, video statement they have said
that will come.
Constructed till lintel level.
That will hear on when the argument starts. Even today, without BBMP, can we pass any orders?
We are not able to, this petitioner or minority communities, they cannot fight with these chains like farmers here. People, non-believers of God, they destroyed an existing temple with a promise that BDA will allot another land, and another land was allotted by BDA to the petitioner trust. But unfortunately, that was a part not for the temple purpose. Allot ಮಾಡಿದ್ರು subsequent BDA. ನಮ್ಮ ಹತ್ರ ಇದು ತಗೊಂಡ್ಬಿಟ್ಟು ಒಂದು ಪಾರ್ಕ್ allot ಮಾಡೋದು.
You want to argue? Please argue. We'll hear you and pass orders. or you want to bring them on record?
The fact now, what is the position?
Please ascertain the fact. What is the point in arguing without knowing the fact?
They are not filed any objection to this effect.
Take Krishna. Learned counsel.
Subsequent application they have to.
It's a counsel submission made on responsible submission. We'll record it. K. Krishna, learned counsel for respond number 1, submits that during the pendency of the above writ petition, respond number 2 had been allotted the land as regard which the petitioner has laid a claim, had been returned by respond number 2, and thereafter allotted to the Growth Bangalore Mahanagar Palike for setting up of a health center, which has been set up. For the setting up of a health center. Learned counsel for the petitioner seeks for and is granted 2 weeks' time to ascertain. ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಖಾಲಿ ಜಾಗ ಇದೆ
ಖಾಲಿ ಜಾಗ ಇದೆ ಆಮೇಲೆ ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಾಗಿದೆ ಅಂದ್ರೆ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ರಿಪಿಟಿಷನ್ ಒರಿಜಿನಲ್ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಗೆ ಅಲಾಟ್ ಆಗಿ ತಿರ್ಗಾ ಅವ್ರ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ there are several other things which is not ಇದೇ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಒಂದು 10 ಕೇಸಸ್ ಇದೆ
ಕೇಸಸ್ ಇದೆಯಾ
I will give the numbers.
ನಂಬರ್ಸ್ ಇದ್ರೆ ಆರ್ಡರ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ
ರಿಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಎಲ್ಲ ಹೇಳಿ
10 ಇರ್ಲಿ 20 ಇರ್ಲಿ ಎಲ್ಲ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ
ಅದಕ್ಕೆ at least RTA
Shri Ramananda, learned counsel for the petitioner, seeks for and is granted 4 weeks' time to ascertain the facts and take necessary steps. He further submits that there are several litigations which had been filed as regard the subject property. Ella disposed of pending. He is permitted to furnish a list thereof. Shri K. Krishna is also directed to ascertain if any litigation has been filed and the status thereof and make the submissions. Released on 28/6.
Submission this court has offered in the PDA even now petitioner are ready to take any alternative side.
ಅದು ಅವ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
Alternative side is CS side for reason for me. I have notified my instruction whenever CS sides are notified, we will give preference to the petitioner. That is the instruction.
You can apply and they will give you proof.
Because it has to be allotted as
When I wanted to withdraw the side, they gave the side, withdraw the petition, they gave a side, CS side, it was a park. So naturally I have to file the petition because I cannot take the park for the religious activities. So that's how they themselves are granted the.
What do you want to set up here?
This court had recorded.
Hala, either what do you want to set up in that land?
A temple and other trust because they are minority Saraswati Brahmins community. They wanted to have a temple and
Temple ಮಾಡಬೇಕು.
Temple ಮತ್ತೆ community center library for which it was allotted, CSA was allotted for construction of library, community center and other things. All were constructed in the year 1986. From 76 it was constructed and the building came to lintel level. Then the growing neighboring PS college filed several residents at PAL litigation and what has they ordered that the petitioner should not construct it, further construct. At that time, the PDA had taken a construction. In the PDA had taken contention in favor of the petitioner trust that the building has come to lintel level and the PAL is rulers and this honorable court dismissed the rulers.
Photographs produce ಮಾಡಿದ್ದೀರಾ?
ಎಲ್ಲ application with other representation of the
report speak whether they are construction or not. And electoral make the submission.
We'll have it on 28th ಅಷ್ಟೊಳಗೆ ಏನು ಮಾಡ್ತೀವಿ? Response number 1. Response number 2. In the second matter, Mr. Krishna?
Yes, ma'am. 13 to 7.
7957 only? 1 and 2. Mesra illa alli. ನಿಮ್ಮ ನಾವು ಬಿಪಿ ನೆಗಡಿ ಅವರ ಹೆಸರು ನೋಡ್ತಾ ಇದೀವಿ. 1 and 2, 3.
I appear for the petitioner in 13-227.
Yes. Ready?
Ready, my lord.
Ready, Mr. Krishna? Yes, sir. What about respondent number 2, Beka, 2 to 4? V. Rupesha and Sandeep. Really? Mr. Rupesh, Sandeep, Shivaji Rao, K.S. Narayan Swami are 5 to 7. (13, 2 to 7). Though counsel for the petitioner is present and ready to address his arguments, so also counsel for respondent number 1 is also ready to address his arguments. None appears for respondent number 2 to 4. In the interest of justice, one last opportunity is granted for respondent number 2 to 4 to be represented in the matter. If none were to be present for the respondent on 7/6/2022, it is made clear that the matter would be taken up for consideration in their absence. 66.1. None appears for the petitioner. Counsel for respondent number 1 and 2 is present and ready to address his arguments. None appears for respondent number 3 and 5 to 7. In the interest of justice, one more opportunity is granted for said counsels to appear and address their arguments. If the counsel for petitioner were not to be present on 7/6/2022, the petition would be liable to be dismissed for non-prosecution. If the counsels for respondents were not present on the next date of hearing, the matter would be taken up for consideration in their absence. Relist on 7/6/2022.
Let's appear for the petitions in this matter. Let's kindly pass over the matter and keep it at 2:30, my lords. My senior will be present in the court. Oblige, my lords.
File ಮಾಡಿದರೆ objection, sir? ಮಾಡಬೇಕಾ ಬೇಡವಾ? Mr. Dinesh Rao. None appears for the petitioner, though the counsel for the respondent is present and ready to address arguments. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Relist on 7/6/2022.
17.
Shri Unni Krishnan has entered appearance for the respondent. Registry is directed to delete the name of Shri Vipin Negde as that appearing for the respondent. Mr. Mahalinga Bhatt. None appears for the petitioner. If none were to appear for the petitioner on the next date, the petition will be liable to be dismissed for non-prosecution. Relist on 7/6.
71.
Shri Karthik C has entered appearance for the petitioner. The registry is that delete the name of Shri Dasraj as that appearing for the petitioner. None appears for the petitioner. Kotari. or for respondent number 2. If none were to appear for the petition on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 7/6.
72.
Mr. Basaraj. None appear for the petitioner or respondent number 2, 3. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 7/6.
74 dismiss. 75.
None appears for the petitioner, though the counsel for respondent is present and ready to address arguments. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 7/6/2022.
76.
Senior is not well. Please convey our best wishes to 76, 3 weeks. 3 weeks. It is submitted that the arguing counsel is indisposed and would not be able to attend court for at least 3 weeks. Hence released on 28/6/2022.
77.
77. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 7/6.
78, 79 items. 80.
My lord, my apologies. Serial number 77, my lord.
Yes, Mr. Chandra, 77.
My apologies, my lord. My lord,
So appears for the respondent in 77. 77 order change. 77 counsel for the. You're ready?
I'm ready, my lord. It's a simpliciter writ for mandamus.
Counsel for the petitioner is present and ready to address his arguments. However, none appears for the respondents. If none were to appear for the respondent on the next date of hearing, the petition will be taken up for consideration in their absence. Released on 31/5.
Grateful.
ಎಲ್ಲ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಮ್ಯಾಟರ್ಸ್ ಆಯ್ತು ಇದೆಯಾ ಮತ್ತೆ ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ all these matters none are appearing. If there is some substance they should have appeared. Appearance ಆದ್ರೂ ಟೈಮ್ ಕೇಳಲಿ ಅಪಿಯರೆನ್ಸ್ ಇಲ್ಲದೆ ಹೆಂಗೆ ಅಪಿಯರ್ ಆಗಿ ಟೈಮ್ ಕೇಳ ಅಪಿಯರ್ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಡಿಸ್ಮಿಸ್ ಅಂತ ಅಷ್ಟೇ. Some appearance has to be there. 80. None appears for the petitioner, though counsel for the respondent is present and ready to address his arguments. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to dismiss for non-prosecution. Released on 7/6. Then why should we? It would be embarrassing for them for us to record that none appears. But appearance agli andre ನಾವು record ಮಾಡಲೇಬೇಕು. ಎಲ್ಲರೂ ಡೇಟ್ 7/6. ಅವತ್ತು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್. ಏನು ಇದೆಯೋ ಇಲ್ವೋ ಏನು ಮಾಡಕ್ಕೆ.
I appear for the respondent, Your Lordship, for 81. Appraised time, Your Lordship.
ಏನು ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಪೆಂಡೆನ್ಸಿ ಎನಿಥಿಂಗ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಮಿಸ್ಟರ್ ಕಿರಣ್ ಆರ್
Lordship, office shift ಆಗ್ತಿದೆ. I am not having my file.
ಫೈಲೇ ಇಲ್ವಾ? ಶ್ರೀ Kiran CV has entered appearance for respondent number 1 and 2. Hence, registry direct delete name of Sri Narendra Gowda as that appearing for respondent number 1 and 2. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to be dismissed for non-prosecution. Pre-list on 7/6. Mr. Muralidhar. None appears for the petitioner, though counsel for respondent number 1 is present and ready now. He is present. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to be dismissed for non-prosecution. Relist on 7/6/2022. None appears for both the parties. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to be dismissed for non-prosecution. Relist on 7/6. Yes, Mr. Prakash. Ready? $29 to consent award. In litigation pending idea. Page 48 is the relevant portion. 48 is the B schedule, right? Yavudu property entry. 159, 1 acre, 39 meters. ಇದು 39 ಗುಂಟಸ್ ಇದೆ. ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 4 acre 30 ಗುಂಟೆ. They have not come as that, nor they have appeared. So far as the extent of monetary service can be petitioners since the respondents have not they appeared, I have lost allowed entirely. Set aside admale 2 different awards agutte. You can spread up for no problem. They have to come forward. Tomorrow they may say, we are entitled to interest and ask. Our consent illa, your consent is there. Your consent is there. That's the extent to worship. ನೆನ್ನೆ ತೋರಿಸಿದ್ರಲ್ಲ ಸೇಮ್ ನೆನ್ನೆ ತೋರಿಸಿದ್ ಸೇಮ್ ನೆನ್ನೆ ಇನ್ನೊಂದಕ್ಕೆ ಯಾವುದಕ್ಕೋ ಕೊಟ್ಟರು ನೀವೇ ಕೊಟ್ಟರೆ the petitioner is before this court seeking for the following relief. The petitioners and respondent number 3 and 4 are said to be the owners of 2 acres 39 guntas of land in survey number 159 of Chiluru village, Oralli, Kanakpura Taluka. The entire land was acquired under final notification under section 28(4) of the Karnataka Industrial Area Development Act issued on 2/2/2010 The petitioners herein had approached the KIADB for a consent award in terms of section 29(2) of the KIAD Act. However, since respondent number 3 and 4 did not cooperate, a general order award came to be passed on 30/12/2013, and the compensation came to be deposited in civil court. Correct. In the meanwhile, the petitioners who had filed a suit in OS number 373 of 2021 for declaration of title in respect of 1 acre 39 guntas in survey number 159 of Chiluru village, Ruralli, Kanakpura Taluk, ended in a compromise, and the petitioners were recognized to be, were declared to be the absolute owners of the aforesaid land measuring 1 acre 39 guntas. It is in that background that the petitioners are now challenging the general award dated 30/12/2013 with a liberty, with a direction to the KIADB to award compensation in by way of a consent award under section 29 in terms of section 29(2) of the KIAD Act. Correct. With the submission of Shri M.H. Prakash, Learned Counsel, that a similar matter has been decided by this court in WP number 330 of 2022 by order dated 11/1/2022. He submits that similar order could be passed in the present matter. Shri P.V. Chandrasekhar, Learned Counsel, appearing for KIADB respondent number 2, has no objection for the same. Respondent number 3 and 4, being the other family members who are being served, have not entered appearance. In the above background, I pass the following order. Writ petition is allowed. The impugned general award dated 30/12/2013 in so and so in respect of to an extent of 1 acre 39 guntas in survey number 159 of Chiluru village, Ruralli, so and so, is hereby quashed. Respondent number 3, SLO, is directed. Respondent number 2, SLO. Respondent number 2, SLO, is directed to consider the claim of the petitioner under section 29(2) of the KIAD Act 1966 within a period of 4 months from the date of receipt of a copy of this order. The respondent number 3 shall act upon a printout of the uploaded copy of this order without insisting on a certified copy. If the respondent number 2 has any doubt about the order, he can always seek for clarification from the counsel appearing on his behalf in the above matter, or from visiting the website of the High Court of Karnataka. The amount in deposit before the civil court to an extent of 1 acre 39 guntas of so and so village is permitted to be withdrawn by respondent number 2 SLO for onward disbursal to the petitioner after passing of the award. Again, declaration ಆಗಿ ಅದು ಪೆಂಡಿಂಗ್ ಇತ್ತು, ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಪೇಮೆಂಟ್ ಆದ್ಮೇಲೆ ರಿವೈವ್ ಹೆಂಗ್ ಮಾಡೋದು ಮಿಸ್ಟರ್ ಅಭಿಷೇಕ್? ಹೆಂಗೆ ರಿವೈವ್ ಮಾಡೋದು? It is made clear that in the event of any dispute arising as regards the entitlement and or the apportionment of the award amount, the general award, which has now been washed, would stand revived. ಹೆಂಗೆ ಅಂತ ನಿಮ್ಗೆ ಏನೋ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ಏನೋ ಹೇಳ್ತೀರಾ, ಬಟ್ ಹೌ ವಿಲ್ ದಟ್ ಹ್ಯಾಪನ್? ಇಲ್ಲಪ್ಪ, ಇವಾಗ ಇಲ್ಲಿ ಅವಾರ್ಡ್ ಮಾಡ್ಬಿಟ್ಟು ಇದ್ ಮಾಡಿದ್ಮೇಲೆ ಪಾಶ್ ಆಗಿರೋದು ರಿವೈವಲ್ ಹೆಂಗಾಗತ್ತೆ? ರಿವೈವ್ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡೋದು? ಏನದು ವಾಪಸ್ ಕೊಡಿ ದುಡ್ಡು ಅಂತ? Liberty, we can reserve liberty to you to initiate such action if there's a dispute. But if revive, ಸ್ವಲ್ಪ doubt ಇದೆ. Revive doubt ಇದೆ. It may not even help you to take such action ಅಂತ ನಿಮ್ಗೆ ತಗೊಂಡ್ರೆ ಅದು ಬೇರೆ. 4 months. ಮತ್ತೆ ಯಾರು ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಲ್ಲ, ಮೇಲೆ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಂತ ಹೇಳಿ, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಂತ there was a dispute as regards the land in 159. Is it 2:30? They wanted it at 2:30. Yes, Mr. Arun, you are waiting for something?
Serial number 84. Maybe taken after 2 weeks, my lord.
84.
84, my lord.
Ajay ಆಗಿದೆ 84 ಯಾವುದು? 7 June.
My lord.
84 change ಮಾಡಿ ಅದು ಆರ್ಡರ್. At the request of the council, since Sri Shanmugappa has entered appearance for the petitioner, registry is directed to delete the name of Sri Kalimullah Sharif as that appearing for the petitioner. At the request of the council for the petitioner, released on 7/6/2022.
ಸರ್ ಎಲ್ಲ ಇದು ಪಾಸ್ಡ್ ಓವರ್ ಇವಾಗ.
Court officer. Court officer.
ಹೆಸರೇ ಬರ್ತಾ ಇಲ್ಲ ಅದ್ರ ಒಳಗಡೆ.
Court officer? Court officer?
ಹೇಳಿ ಸರ್. ರೂಪೇಶ್ ಸರ್.
ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 61 ಇತ್ತಲ್ಲ, ಏನಾಯ್ತು? 66
76 ಸರ್. ನೆಕ್ಸ್ಟ್ ಡೇಟು
76 ಬಿ ರೂಪೇಶ್ ಅಂತ ಮೇಡಮ್. ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಅವ್ರದ್ದು.
ಅದು ಶೈಲೇಂದ್ರ ಕುಮಾರ್ ಕಮಿಟಿ ರೆಫರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ಬಿಡಿಎಂ ಅದಕ್ಕೆ ಹೋಗಿ ಮೆನ್ಷನ್ ಮಾಡಿ 4 ವಾರ ಟೈಮ್ ತಗೊಂಡು ನಾನು ಬೆಳಿಗ್ಗೆ ಕೂತಿದ್ದೀನಿ ಇನ್ನೊಂದು ಕೋಟಲ್ಲಿ ರಸೀದಿ ನಂಬರ್ 11 ಬಂದಿದೆ ನಾನು ಅದೆಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಮತ್ತೆ ನಾನು ಅದೇ ಇವಾಗ ಇನ್ನೊಂದು 2 ಮ್ಯಾಚ್ ಅದು ಇಲ್ಲಾಂದ್ರೆ ಡೀಟೇಲ್ಸ್ ಆಮೇಲೆ ಫೋನ್ ಮಾಡ್ತೀನಿ. ಈಗ ಬಂದೆ ನಾನು ಈಗ ಅದೇ ಇನ್ನಷ್ಟು ಹೇಳ್ತಾ ಇದ್ದವ ಈಗ ಅಷ್ಟೇ ಬಂದೆ ಅಲ್ಲಿ
after matters. Serial number 58.
Sorry? There are only 2 items. You take it as next item, but there are only 2 items. You must be aware of it. I have already informed.
67.
Both of you will have to keep us occupied till the council comes in that matter. Yes.
This is a fourth round of litigation. It was a site allotted to the school. The composite area of the site was 6,609 square meters.
6,000?
609 square meters. In that 3,969 square meters was allotted to the school in the year 1990. What are the year?
3,600? 96.
Yes.
In the year 1990.
1990. So the whole composite is 6,606 million. The land was not fenced, the school was built, and the school had commenced. After that, in the year 1990, 91, the remaining portion was given to the youth services.
Just a moment. You are. One more, you are appearing for respond number 2.
Yes.
Respond number 1 is Mr. Charity. Respond number 3, Mr. SM Suresh. Who are missing with the library. Is he required? No, when we saw the number of people, 1 was missing. So who is that person missing? Is no relief has been sought.
He is one of the allottees, but I am not one of the allottees. He is also one of the allottees.
If it doesn't come, it doesn't come. Yes.
So a notification was issued for law and 3,969 square meters. That's the community site 36 areas to the school. Then the project received legal possession of it at the school in 2022. Then in the year 1991, the remaining portion was announced for availability of a civic community site, and it was reserved for the social and cultural center, measuring 32 into 25 meters. That was the remaining portion was given to the social and cultural institution. At that point of time, we filed a requisition. The allotment order was set aside in favor of the Youth Services Authority, and the court had directed to consider our case also. We have been giving representation time in and time out. Again, in the year 2005, the land was allotted to the remaining portion next to the school was allotted to the Hindustan Petroleum Corporation for 30 years. We again challenged it. If your lordship may see annexure E money.
Page number?
Page number 50. Since the land was not reserved as per sub-rule 1 of rule 3, the court allowed the petition and directed the operator portion of the The petition is allowed the allotment of signed in favor of the second respondent, as well as the petitioner after the demand of the matter is hereby quashed. The authority shall strictly follow the rules. Rule 3 of the BDA, allotment of civic community site rules, 1989, in disposing of the balance civic community sites in the faucet layer. If they intend to preserve it, they should pass an order under section 3(1). If it is not reserved, the said statute will be offered for the purpose of allotment on B, the lease basis to all institutions by issuing a paper application and inviting such application, consider their relevant merits and claims and pass appropriate orders. If the second respondent seeks a refund, the money shall be paid. However, notwithstanding this order, it is open to the petitioner, my lord, as well as the second respondent to approach the BDA when it is offered for lease to apply, and the case of all these people may be considered by the BDA on its merits and in accordance with law, without in any way being influenced by any of the observations made in this order. Again, my lord, the next is soon as after this order was passed in the year 2007, my lord. Orders were passed, we have been filing representations, my lord. At that point of time, again, they have allotted this to Anandra Pratistana, who are one of the respondents herein, and to the Bharat Muslim Sangh, without inviting and reserving it or considering all of it. So we had filed another petition, the court had directed the next year. In page 61. Again, the order was quashed and the court directed in the result, the petition is allowed and the allotment made in favor of respondent 2 and 3 as per election G and J are quashed. The first respondent is directed to deal with the site in question in terms of the directions issued in the order dated 7/8/2007 passed in WP number 15901/2006 NSA. Needless to observe that petitioner, second and third respondent are entitled to apply for allotment as and when the first respondent notifies the second question. Again, the site was notified in the year 2013. It was a paper publication. The site was notified. We have filed an application on 7/1/2013 for social and cultural and for a training institute.
So earlier there was no notification. Now this is a notification in the year 2013. Yes.
But if your lordship may see about the additional documents, they have given it to the second and third respondent. They were not in the site for the second. We had applied.
Were the second and third respondent also applicants? Second and third respondents were also applicants. You were also an applicant.
There was a paper publication, and based on that, we have all applied.
Yes.
But they have not considered my case again. They have allotted it to the second and third respondent, and they have returned our amount without considering. Your lordship may see there.
How were they supposed to consider it, madam? When you say they have not.
Your lordship may see they have to consider because we have been applying, and it is one composite unit in the school, there's no demarcation. So we had applied. Your lordship may see annexure, the additional documents, where they have stated that they have not even considered our case. Of the note sheet of your lordship may see. So on the
Where is
last
the page number?
the translated copies in the next page. In the meeting, they have not said anything.
Where
about
additional document, in additional documents.
Regarding site number 36 part A.
Just a minute.
16 applications that see for allotment of solar.
We haven't got it as it.
And 5.
2000 date.
The third one will celebrate 18 June 2014.
Yes, we got it.
No, my lord.
But there is no document produced along with it. It's only an
The note
affidavit.
sheets, along with the application, there are.
Application number 151.
Next.
Please stay the allotment letter, etc. But there is no document. You have produced.
Yeah. Those are the motions of the PTA. On the last occasion, when the matter had come up, the court had directed them.
Yes, there's another application.
The court had directed them to produce the records.
Yes.
So here were not both the cases, they have not considered our case number. So we have been applying, and an earlier case was there were not, and the court had directed the PTA to consider our case in file application.
So you say that
There's a passing remark that they had filed a petition number 36789 of 2009 before I showed the background.
page number?
It's in the edition.
Yes.
Yes.
What is the page?
Translated copy.
What is the page number? So we don't see any reference to the writ petition. Akshara Cultural and Education Society for purpose of running a training center. By levying, there's no mention of anything. Yes. And meeting dated so and so. 36/A P2 measuring 1000 square meters, situated so and so. Neither your name is mentioned nor any writ petition number is mentioned.
Okay, no, the next page.
Next page. Oh, there is one more. Okay. Oh, there are two allotments.
Yes, there are two.
P1 and P2. Site allotment as filed with petition. Cultural, yes.
So even here, they have not considered our case, but we have filed applications. There is a previous history of where the court had directed them to consider our case. They have not considered not even the passing.
Why do you need this property? For what purpose have you applied for?
It's school.
For the expansion of this.
This area is used as a playground. This is a composite unit of 6,696 square meters. So the school is 3,969, and the remaining portion is used as a playground. And it's not even fenced.
Yes. There's no charity.
We have filed an objections to that petition. Earlier, round of litigation, there was, we had granted the civil community site, which was challenged by them. And this honorable court said that you have to publish and then allow.
Yes.
But now it has been published and allowed. But at the outset,
No, was that an empty form? Was that an empty formality to be done, Mr. Pannu?
No, actually, it's not an empty formality. But they have considered, but not in the way, generally, once a matter is demanded, that they have to say that we have considered. But it is not.
Okay. Can you show us in that order, in both the orders, P1 and P2, where is the consideration? Page 15. Sorry, page 11. Now that we'll come to that later. Page 11 is the first one. To Akshara Cultural and Education. along with the application that was filed on 18/6. The first item, there are two subjects. One is subject number 1, both are 186 only. And both are subject number 1 and 186. Annexure W is one, annexure Y is the other one, right? That is what is being challenged.
Right. With the objection, they have also used that.
Wherever you want to refer, it's fine. It's the same.
Yes.
There's no difference in what you have produced.
No, I'm only saying that we also have produced it, just to say that it's not that we are trying to. Turns to page 10 for the entire we are trying. Not be the real sense that they have said, but looking into it, because if holistic approach is taken, that it's not that they are not considered it. So they may not have said so in so many words.
Show us from,
I do accept that.
Show us from page 10, 11 and 12 as regards the allotment made to Akshara Cultural Education Society. What is the consideration of the application filed by the petitioner? Regarding site number 36A, P2 meeting house. Yes.
It is what the earlier the court had said was that without publication, without publicizing, and without calling others, you cannot give. So that we thought that is not questioned by them. No, whether or not we have to give it to them or give it to somebody else. Once an advertisement has been made, then we consider as to who should get it. And if we have said that it's pursuant to the order of this honorable court, but then I would submit that the consideration is there. But as I said, that it cannot be.
Show us the consideration.
Here, what they say is.
Show the consideration of the application.
Statement of objection.
No, we have marked this one, so please restrict me. We don't want to shift to both. Page 11 of that application and annexure W. If you don't have it, we'll go to your side.
Paragraph 1. The last 3 lines.
Yes. Adu Yurdo. Respond number. Where did they allot? Now we are referring to Akshara Cultural. There are 2 petitioner respondents. Which one do you want to take up? Akshara you want to take up first, or you want to take up Anna Crew? You want to take Anna Crew, or you want to take Akshara? There are 2 resolutions. Anna Crew. Annexure W is Akshara. Page 11. Namatra irodu. Annexure Y is Anna Crew.
Annexure Y is Anna. That's what. Why it should be given to Anna Crew or to the other one or that you have stated? We have called for after the direction of this court.
You said you consider the application of the petitioner from annexure W. Please show us where you have considered it and tell that.
What I'm trying to submit, I get what you're also saying. May I just say this and then I come back to it. Now the order of the learning that is of this honorable court on 2 occasions was to publish it and then grant to whom, because that discretion is vested with the media to give it to whom whom they think is better.
You are
This is not a case
the king and emperor. You can
this is
do.
not a case where marks will be given or comparative merit has to be seen. Like it's not incumbent on our part to say that he is more meritorious or he is less meritorious.
So what are the concerns?
They are already an allotment. They have already got an allotment of 3,969. Already they have got an allotment. And whether once a person has got an allotment and whether they'll again become an allotee or not, that is one question. But second, once they have got an allotment now, whether they can even challenge what we have given.
So your first contention is petitioner is already an allotee, so he does not need to be given any land.
So because we have already given it to them, civic committee has already been given to them in 1990. So then they apply. The same person, why should we? In fact, if the lordship sees the orders at annexure, which have been where they have said, so the directions are because what mediated without calling for application, we granted it. That rightfully, this honorable court set aside, saying that as per the rule they are supposed to publish. But once we publish it, then when we allot to either any of them which we find they require. But how can they even challenge that? They can only go on whether it has been published and whether it has been considered or not. Now, if we consider the merits of the other two and if some reasoning has been given, I admit, if only they had said that I have also considered then
your submission is that since petitioner has already been given a land, he is already an allotee and running a school. Whatever it may be, whether they need it for expansion or not, we are not going to allot to them. Is your contention?
It's not a question of not allowing, but if there was nobody else
so they
who would have been in a better position, whom we felt, then probably it could have been.
What is the basis of asserting? You are an authority. You are not a private person dealing with your own private property.
That is the reason. Now, all that has happened now is it is not that it's not been considered, but I do understand that after an order is passed, we cannot substitute the reason and go back and say that this is what they intended. I do understand that cannot be done. But the issue is whether the direction of this court, what was the direction and what it was meant to be, whether we have followed that or not. Once we follow that direction, we advertise and then we allow it, but then whether the petitioner who is already an allotee, whether he can challenge that or not. If the rules are not being followed.
So who can challenge?
They cannot.
According to you, who can challenge?
What I'm saying is, do they have a right for allotment of the civic community? I asked myself this question. They do not have
and
a right.
what do you answer to your question, Mr.
No, my answer to my question is, if they do have a right for allotment of the civic community, they do not have a right on allotment. And there is,
If
there is
suppose
no fundamental right.
your action of allotting it to somebody, who can question it? If they cannot question it, who can question it according to you?
But what I'm saying is this.
Can anybody question?
The reason they could question earlier.
Can anybody question your order or no, according to you?
But if it has been done in accordance with the rules, what I'm saying is it's not that they cannot question, or I cannot say that they cannot fight. But if they fight, whether they have a right is to be considered by this court. I'm not trying to say that they cannot come to the court. Because they always have that right to come to the court. But whether the court may not consider that case. The reason why they succeeded in the earlier two rounds of litigation was because they had not advertised, they had not called for application. So there was a mistake. So that mistake, it was not as though, the earlier two, if it was so, the courts would have straight away issued a mandamus saying, allot this to the school because they are there. The courts knew that the courts do not have that power to say that.
Probably the court did not realize that the BDA can do something like this.
But BDA does a lot of things.
If the court had realized that that order will be interpreted like this, then the court would have passed that order.
BDA does a lot of things, but our thing is to put our best foot forward to at least.
You are in an unenviable position, we understand that. But unfortunately, you are addressing arguments for BDA, so you'll have to face these questions. You can't help it. Consider.
And it turns to our statement of objection. Filed on 11/7/2014.
Yes.
In that, we will also kindly turn to page 10, internal page 4, page 10. That annexure R1, R of this, trying to be.
Page 10, annexure
R1.
Yes.
And page 10, internal page 4.
Item number 7.
Yes. Now here, if you logic is Sadri Nagarika Saurabhya, Niveshana, Hanchiya, what could article so and so Hanchikalu, Sabi, Governis. So it is not that they are not being considered, but it has been considered. So all the applications have been looked into. And then they have, what I am submitting is this. This is if a person, my lord, as a matter of right, has got, my lord, as a right, then if his case has not been considered or it has not been stated, my lord, then they can see. But they do not have they cannot claim it as a matter of right. No, my lord, if a civic community, if a person applies to civic community, and if it is not given to him, my lord, he cannot come to the court and say that it should be given to me, my lord. Yes, in fact, there is one judgment of the division bench also. So here, but to the extent that is not a fundamental.
Yes.
I only though I go to the main thing, but the logic sees page 4705 in the head note itself. That's at para 2. Your logic may turn to page 4706. It's averred in the petition that these of civic community site is there as the second respondent to illegal allotment of petrol object not civic community, and the second respondent is not entitled to allotment of a civic community site. It is stated that the rules of allotment have not been followed by leasing the site as no public option of it, and the second respondent is putting up construction in violation of so and so, hence he is liable to be quashed. But then para 10. And then para 6, may I request your audience to Malord. Para 6, Malord, at page 4707. No doubt in an appropriate court, this court can issue direction if there is gross violation of fundamental rights or if the issue touches the conscience of the court, but not for personal gain or publicity or political gain. Of course, this is not totally unright, but there cannot be any violation of fundamental rights. But all that I am trying to say is, if they have had a right for allotment, but if they had a right, now if you have applied for it, somebody else also has applied, and we make a discrimination where we are not supposed to, then they can say, I have made an application for allotment, I have made paid the price, I have done everything. You are not given, you have to give, and then this court can give a direction allotment. But here, can this court give a direction to say that it should be allotted to the petitioner or the industry school? Because that is a question which the PDA will have to look into, and that is in the absolute discretion of PDA who to give the civic community. Otherwise, like any time the allotment of civic community is there, then everybody will come to the court saying that we should be allowed. Yes,
what do you mean by
the court if there is violation of certain provisions of the law?
What do you mean by absolute discretion of the
Absolute discretion in the both corners of law. So I'm saying that that they are following the procedure, then if they follow the procedure.
Nobody has any absolute discretion, especially not a statutory authority. Any discretion has to be exercised in a reasonable manner.
Yes, I understand. So
if you show us that you have considered.
I read out that so many applications are there. They have we published the applications came, we considered the application, and then we felt that the respondent 3 and 4 that they better deserve it, and anyway they have been allotted to school. So it is not that they have been, and they have been allotted in the year 1990. So it is not that they can come now and say that we don't have this, we don't have that. If they managed it now. So they have already been given some site. It is not we have not. If DA was that, then we would have given it to them. But we have given it to them a lot of
Are there any-
They want one more allotment. Is this fair on their part also? That I've got one allotment of civic community. Which also is not a matter of right, but it has been given into the school. Then again ask for one more allotment.
Are there any rules that you have formulated for allotment of civic community sites? In those
It is
rules,
as per those rules which are not followed earlier. For that reason, this honorable court lost our.
does those rules provide for the manner of consideration of the application? And do those rules prohibit an earlier allottee from making an application?
There is no express prohibition as far as I see. There is no express prohibition that a person who has been allotted cannot be allotted.
But yeah, rules.
No express prohibition.
Yes.
In this Bangalore development, that's what the allotment of civic community site rules. They have defined allotee civic community site. But again, an institution has been defined allot means an institution, society, or an association. So all these are there, but as you also said,
Come to rule 7.
The question also is about whether he would come in the definition of an institution. I'm not so sure. Though we have allotted it earlier, but still whether
No, don't go there. No, don't go there. If you go there, then we'll have to observe something. Come to rule 7. Come to rule 7 of those rules.
what I am submitting is not if
Come to rule 7 of those rules.
principle of selection of institution for leasing out civic community. The authority shall consider the case of each institution on its merit and shall have special regard to the following principles in making the selection. The objectives and activities of the institution and public costs served by it since its establishment, the financial position of the institution, the present location of the institution, the benefit likely to accrue to the general public of the locality by allotment of civic amenity site, the bona fide and genuineness of the institution as laid out in the annual report, audit report, etc. The need of civic community site by the institution for providing the civic community in question. For the purpose of subject one, the separate committee to be called civic community site allotment committee, consisting of 3 official members and 3 non-official members. The chairman of the authority shall be the chairman of the civic community site allotment committee. Subject to the approval of the authority, the decision of the civic community allotment shall be final. Look, their case is not that these have not been followed.
Their case is not being followed. There has been no consideration of their case.
That is the only thing about where it has not been expressly, not in so many words that is not I cannot into what is there. But if you also have to consider all this, because that they have said so. But if it is seen a lot in totality, it is not that it is done. But if we had to give straight away to them, we wouldn't have said that we have considered those applications. Because the High Court order is mentioned.
Your first contention is that the petitioner has already been allotted, therefore he does not have a right. So there is no consideration. Second contention is that all the applications have been considered and you allotted it to respond number 3.
Yes. And once they have followed the rule, then the petitioner cannot challenge the decision.
And fourth one is your absolute discretion.
We have a discretion.
So you still want
the prefix of absolute.
Absolute, your
absolute.
adjective is gone. So discretion
I will withdraw that absolute
of BDA. So these are your 4 submissions.
No, if there is some allegation of bias or if there is something that I can understand, that is not there. Because that we have tried to give it to somebody. And that is what my learned friends will ask me who are the allotments, not for who and we. They will argue on their respective merits. But it is not their case that we have been biased. So that is the ground. Then then if we have done something and that can be shown which is the malified exercise of power. Here it cannot be said it's a malified exercise. Non-consideration, to the extent that it has not been said so in that order, but otherwise that's all.
Even if something is not mala fide, it could be bad. Just because, even if it is not malified, the decision could be bad.
The decision, my lord, if it's an incorrect decision and it is not malified, yes, my lord, it can. But here, that is not the case.
That you have said, your decision is absolutely 100% correct decision. We have made note of it. Yes, Mr. Manmohan. Yes. Petition. It is managed by the Bolar Education, established in 85 to impart education to the children.
Person before the court not in the school. School body leader, it's not an institution, it's not law, but it is a society.
Yes.
Not the commitment taken us to pay 70 for a moment. 70. This is the notification which for which. So the applications are called for. The advertisement.
70.
70.
Yes.
Next is 10. Can I just come to what conditions, serial number 3. ನಿಯಮ 5ರಲ್ಲಿ ಅಂಕಿತ ಮಾಡಿರುವ ಸಂಸ್ಥೆ ಮಾತ್ರ ಪ್ರಾಧಿಕಾರವು ನಾಗರಿಕ ಸವಲತ್ತು ನಿವೇಶನ ಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಸಂಸ್ಥೆ ಮಾಡುವುದು. ಬಿ ಸಂಸ್ಥೆ ಅಂದರೆ 1940 ಕರ್ನಾಟಕ ಸಂಸ್ಥೆ ಅಧಿನಿಯಮ ಅನ್ವಯ ನಿರ್ದೇಶಿಸಿದ ಒಂದು ಸಂಸ್ಥೆ, ಸೊಸೈಟಿ ಅಥವಾ ಸಂಘ ಅಥವಾ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘ ಅಧಿನಿಯಮ ಅನ್ವಯ ಒಂದಾಗಿರುವ ಸಹಕಾರ ಸಂಘ ಅಥವಾ ಧಾರ್ಮಿಕ ಶಿಕ್ಷಣ ಅಥವಾ ಧಾರ್ಮಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸಂಪೂರ್ಣವಾಗಿ ರಚನೆಯಾಗಿರುವ ಒಂದು ಟ್ರಸ್ಟ್ ಅರ್ಥ. ರೂಲ್ಸ್ allotment of civic entity size.
Yes.
But rule D, 2D. The definition of institution means an institution, society, or society, association registered under the Karnataka Society Registration Act, or a cooperative society registered in the Karnataka Cooperative Society, or trust made only for the charitable education of religious purpose. The petition of the Lord is not a trust. No doubt, but I have to concede that the application that we filed for allotment refers to trust. But the trust is not become allowed.
Is it a charitable education or religious purpose?
It's a trust. That's what the one that we say. But if you also turn to page 71, in the application. It says education trust. Page 71 and 70. Only says Bolar education trust.
Yes.
So my submission to the law is one, Bolar education trust is not become allowed.
The school run by the trust is before the school.
At the most, they have to come before the court, and have very specific context. In fact, the court asked on last occasion to make the learning council for the petition, but of course, they did not respond.
We don't know last occasion. Please don't argue last occasion. Only this occasion. You will say something, then madam will say, we don't know.
My first submission is with regard to maintaining the petition. But my second contention was this: the petitioner would not have any vested right to claim one for allotment of this site.
Yes.
But as what already not been pointed out, petitioner was given what a site way back in 1990. The allotment is at page 28 in Section C. They already not have an allotment in their page.
Yes.
So they want further more extent of land to be allotted in their page.
Is there a prohibition in the rules for such application to be made?
No, there is no specific prohibition, but not given the circumstances.
Did you object in the order passed, when the order was passed by this court, directing the BDA to take out a publication and permitting them to participate? Did you object at that point? You should have raised that issue at that time to say that they cannot participate because they already have a land.
That it was not true. The first one was a slightly different circumstance. The second order that was passed was on the ground that you are not notified.
Yes.
You have taken allotment.
Yes.
Therefore, you make an allotment after notifying it and calling for applications. I don't have any right to object someone else's application. My right pursuant to a notification is to only make an application for allotment.
And the right was conferred. Now, what you are arguing today, you could have argued on that date. Both you and BDA could have argued, saying that we will issue a notification, but the petitioner cannot participate in that. If you have pre-decided that they cannot be entitled because they have another land which has been allotted and they can never be allotted in that, then what is the, that's why we asked you, is it an empty formality?
Rule 6 and also 7.
Yes.
So there is no specific part. But you are given force of approach that has to be adopted. Not the commitment against is not Rule 6. Authority may allow site. Sorry.
Yes.
The authority may allow site on these basis only to an institution that is registered under Rule 5. This again goes back to not 2D.
Yes.
Civic community site shall not be allotted to any institution unless it has a capacity to provide the type of civic community for providing which the site is offered. Then Lord 7. Authority shall consider the case of each institution on its merits and shall have special regard to following principles in making selection. The objective and activity of the institution of public cause served by it since its establishment. Financial position of the institution. Present location of the institution. Benefit likely to accrue to the general public of the locality by allotment of civic community site. The bona fide and genuineness of the institution as made out in annual report, audit report, etc. The need of civic community site by the institution for providing civic community in question.
Yes.
So these are the criteria or not the guidelines on which the allotment.
Now, from these guidelines, please show us in the resolution which has been passed, where any of them, not all, any of them has been considered. It has to be all. That from what we read at page Annexure W, not even one has been considered.
Some consideration so far as my application is concerned.
You are the other one. Yes. Page number?
No, page 11 of my application filed by BDA.
We'll come back to this application. What is the consideration in your page 11? Shell number 8 and
No, shell number 7.
7. Okay. 8 is the other one.
Shell number 7 starts at page 10.
Yes.
Suddenly, non-verified over the information to input the there will be the Radhika Sabhi, Vishay number 4 to Henne Vette, Agni, Shakara, Adesha Sutton, the 4 to Anna through Pratishthan, the Egale, they, Nagarika Solution, E. Edavadi, Mr. Anna to Pratishthan, something Guru Adhikar, Adhikar, to Nemor, and the Mother of Karna. If we so for one Uchana, and the one Uchana, so another distance and the ಕನ್ನಡ ಸಾಹಿತ್ಯ ಲೋಕದ ಅಗ್ರಮಾನ್ಯ ಕವಿಯಾಗಿದ್ದ ಕನ್ನಡದ ಸಾಹಿತ್ಯ ಲೋಕದ ಏಳಿಸಲು ಹಗಲಿರುವುದನ್ನು ಶ್ರಮಿಸಿರುವ ಅಂಶವನ್ನು ಸಭೆ ಮಂಡಿಸಿ ಮೊದಲಿಗೆ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಲೋಕಕ್ಕೆ ಸಲ್ಲಿಸಿರುವ ಅವಿಸ್ಮರಣೀಯ ಸೇವೆಯನ್ನು ಗುರುತಿಸಿ ಅನಕ್ರು ಅವರ ಹೆಸರಿನಲ್ಲಿ ಈ ಟ್ರಸ್ಟ್ ಅನ್ನು ಸ್ಥಾಪಿಸುವ ಅಂಶವನ್ನು ಸಭೆಯು ಗಮನಿಸಿ ಅನಕ್ರು ಪ್ರತಿಷ್ಠಾನ ಸಂಸ್ಥೆ ಸಾಹಿತ್ಯ ಕಲೆ ಸಂಗೀತ
ಅದು ಏನ್ ಮಾಡ್ತಾ ಇದೆ ಅಂತ what the person who on basis of whom is been named was, that is fine, but where are these item number 7A to F ಓದಿ ಮುಂದೆನೂ ಇದುವರೆಗೂ ಅಂತ ಹೇಳಿದ್ರು. ಗುರುತು ಸಿ ಶ್ರೀ
ಸಂಗೀತ ನಾಟಕ ಇತ್ಯಾದಿ ಸಾಂಸ್ಕೃತಿಕ ಹಲವಾರು ವರ್ಷಗಳಿಂದ ನಡೆಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು. It is not for all these years we have been carrying on. That is what work we have done earlier.
Yes.
Nadoja, so and so, Supraji, Ashok, so Jeshri Rao, Dr. So and so, ಮತ್ತಿತರರು ಕಲೆ ಮತ್ತು ಸಾಹಿತ್ಯ ಲೋಕದ ದಿಗ್ಗಜರು ಸೃಷ್ಟಿಗಳಾಗಿ ತಮ್ಮ ಅಮೂಲ್ಯವಾದ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಿರುವ ಅಂಶಗಳನ್ನು ಸಭೆ ಗಮನಿಸಿ. ಅದು
ಏನು ಪ್ರಾಬ್ಲಮ್? This is also fine. Now we know why you are here.
ಸೂಚನೆಗಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಅರ್ಹರಾಗಿರುವ ಕಾರಣ ಅದರಿ ನಾಗರಿಕ ಸ್ವರೂಪ ವಿನಿಯೋಗ ಸಂಸ್ಥೆಗೆ ಪರವಾಗಿ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ನಾಗರಿಕ ಸ್ವರೂಪ ವಿಶೇಷ ಸಂಸ್ಥೆಗಳಿಸಿ 30 ವರ್ಷಗಳ ವೃತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಸಾಮಾಜಿಕ ಸಾಂಸ್ಕೃತಿಕ ಚಟುವಟಿಕೆಯನ್ನು ನಡೆಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಾತ್ರ ಹಂಚಿಕೆ ಮಾಡಬೇಕು. There is some consideration insofar as what my application is concerned. But the only thing is this allotment that we made first was a data problem. Two not, I do not comply with the requirements to get wage allotment in mind. Only ground on which not the petition is harping on with some court is that their application has not been considered. So not that assuming what is illegality. Of course not first round, but I have to consider that to consider. Number even the second round where the some court was directed. In terms of that order is what is mentioned. I do not shy away from mentioning that.
Mr. Manmohan, what is playing in our mind, let us tell you. There is a school already in existence in a place. That school requires another land. He has been using this land as a playground. They wanted the allotment to be made to the school and not to a third party. That school cannot be shifted elsewhere. You can be allotted land somewhere else. That is why one of the consideration at 7C is the present location of the institution. So if the institution is next to this land, the preference should be given. That has not been considered.
That when an institution has already been given land, we utilize this portion according to the land, despite there is no allotment in there. I think that there is already an allotment to the extent of 3,969 square meters.
What is that for a school, Mr. Man? Why do you want to come in the way of a school giving education? You can be given, we can direct them to give another land to you. They'll be happy to give you another land because they already approved it. Mr. Charity will find a bigger land for you.
No land, the second round that I am facing.
Don't come in the way of a school running.
But it will not come in the school running, but they have enough land.
Then you will take it and give it to them. Free of cost.
3,969 square meters of land.
40,000 square feet.
Yes.
What is
almost an acre of land
for a school?
Yes, but there are multiple number of schools which are lesser extent of time. And they should have thought about it before establishing the school. But what they did, they established the school on the basis of this 3,969 square meters. It is not the case that the extent, the remaining extent of land was allotted to the school.
It is not that case.
Therefore, when such is the case, when they establish the school, this is the only extent that was available. But can they say, not I am entitled for allotment of even the neighboring extent of land?
No, we cannot direct it, but there is no consideration of that.
I understand, not consideration, not in all, not the fairness. But they cannot say that the entire extent of land should be allotted to them alone. So only one more submission, but if I go from the limit of the effect to content, that not even assuming that there is some illegality, there is not consideration. But even that would not be a ground to interfere with.
Para? Yes.
May not strike down an illegal order, although it would be lawful to do so. In a given case, the High Court of this court may refuse to extend the benefit of its discretionary to the applicant. Furthermore, the court exercises discretion restriction under Article 130 of the Constitution, which need not be exercised in case of the true judgment is found erroneous, if by reason thereof substantial justice will be done. There's only one more submission. So the clause should turn toward the notification. Page 70.
Yes.
Page 70. Seal number 7 is the purpose for which not this was notified. Column number 6 notified.
Yes.
Seal number 7. JP Nagar second phase. But Samajika Mattu Samskrita Bhavana. The purpose. The next one.
We did notice and we have circled it also. We did notice that. And why it has been mentioned that also is clearly apparent.
But then you know the point would be second, even not the next one, seal number 8.
Yes.
No, this notification is not being sent. So application is filed pursuant to this notification.
Yes.
Therefore, the purpose for which not it is reserved or not it is categorized not under the notification. But that is not their application at all. Therefore, not by virtue of the reservation of the area,
yes,
for the purpose of Samajika Bhavana, but the petitioner would have no right to challenge this, unless not it would challenge the very notification itself, which evidently they have not done. On the contrary, they filed an application seeking not for allotment of the land. And that too, not according to the limits for a playground, which is not one of the which is not the reason for which it is reserved.
Yes.
So on that count also, the petitioner would not be entitled to maintain the restriction in the absence of challenge not to election end.
Yes.
But I understand not what's running in Lord's mind that the school children will need it. But not the school should have considered, but on that point, we not, I should not give it this offer because not, I would also want to not establish not this, not government for the purpose of not propagating not the general literature. And not, this is the second round not which I am facing. So I'm not in a position not to consult upon or not to proceed with not any of my.
Yes. Petitioner is before this court seeking for the following reasons. Petitioner is a school managed by the Bolar Educational Trust, stated to be established in the year 1985 to impart education to the children of JP Nagar and surrounding areas. The school having been affiliated to the Indian School Certificate Examination, New Delhi ICSE board. The petitioner claims to have 850 students on his rolls from pre-nursery to standard 10. Correct. The petitioner, the said trust had earlier applied for and was granted on lease in the year 1990. Site bearing number 36, Saraki first phase, measuring 49 meters into 81 meters, totally amounting to 3969 square meters for the purpose of running of the school. Subsequent thereto, the petitioner has established the school and is running the school as apostate. It is a condition of the petitioner that though the allotment made to the petitioner was only an extent of 3969 square meters, the entire land, the neighboring abutting land was also fenced and permitted to be used by the petitioner in all amounting to 6609 square meters. That is in the entire civic community site number 36. The petitioner making use of the said land had made several representations to the respondent number 1 seeking for allotment of the balanced land. However, instead of doing so, respondent number 1 had issued a notification in the year 1991 notifying the availability of an extent of 875 square meters, bracket 35 into 25 meters, for allotment as a civic community. The residents had filed a writ petition WP number 2261 of 1992, challenging the said notification. This court had granted an interim order which was enforced until the dismissal of the writ petition on 26/5/1997 on the ground that the petition was based on apprehensions of the petitioner and there are no valid ground, no facts which are placed to establish such an allotment to be made to a third party. Subsequently, the adjoining property was allotted to the Department of Youth Services and Sports Youth Center in the year 2001, which again came to be challenged by the petitioner before this court in WP number 30050 of 2001. And this court, while ordered it 11/2/2005, set aside the allotment and directed the BTA, respondent number 1, to reconsider the decision after ascertaining the requirement of the petitioner. This court, in its order, had also directed had also permitted the petitioner as also the youth Department of Youth to approach the Bangalore Development Authority for allotment of the land. Subsequent thereto, the petitioner submitted various representations seeking for allotment of the said land in favor of the petitioner. The respondent number 1, however, rejected the said request while its order dated 2/11/2009 and sought to allot site number 36/A, bracket P1 measuring 1640 square meters to second respondent and an extent of 1000 square meters in 36/A P2 to the third respondent. These allotments were challenged by the petitioner in WP number 36787 of 2009, which came to be allowed by this court by its order date 31/1/2012. The allotment in favor of the second and third respondent was quashed, and the Bangalore Development Authority was directed to deal with the said civic community site in terms of the directions issued in WP number 15901 of 2006 by order dated 7/8/2007. Subsequent thereto, the Bangalore Development Authority issued a notification on 13/1/2013 calling for applications for allotment of sites under the civic community under the BDA bracket allotment of civic community sites bracket close rules 1989. Both the petitioner and respondent number 2 and 3 applied by submitting their application, documents, and the required amounts. The Bangalore Development Authority, by its resolution dated 22/10/2013, by subject number 1 of 13 and 186 of 2013, allotted site number 36/A P1, measuring 1640 square meters to the second respondent and 1000 square meters to the third respondent, respectively. It is a said allotment which is under challenge before this court in the present petition. Srimati Rosam Paramal, learned counsel for the petitioner, would submit that the resolutions which had been passed by subject number 1 of 13 and 186 of 2013 are in violation of the BDA bracket allotment of civic community site rules, the rules, inasmuch as there is no consideration of any of the aspects required to be considered under said rules. The respondent number 1 has acted under a preconceived notion and having pre-decided that the property have to be allotted to respondent number 2 and 3, has gone ahead and allotted the same. There is no consideration of the requirement of the petitioner, and as such, respondent number 1 is the BDA has violated the orders passed by this court, both in WP number 36787 of 2009 and WP number 15901 of 2006. And as such, there being no consideration, the orders which have been passed and which have been impugned herein are required to be quashed, as also the representation, the application filed by the petitioner to be considered in terms of the rules. Shri Gurudas Kannur, learned senior counsel, instructed by Shri Murgesh Cheraki, learned counsel appearing for respondent number 1, submits that the petitioner having been already allotted 3,696 square meters in the year 1990, there is no vested right in favor of, created in favor of the petitioner for allotment of further land. The petitioner he further submits that once the petitioner has been allotted a land, the petitioner would not be entitled to any further allotment. Thank you. Submits that there is no right west, there is no that the grounds of challenge made by the petitioner are unsustainable, inasmuch as there is no vested right created for allotment in favor of the petitioner. And as long as the discretion vested with the BDA is excised in a proper and required manner, the petitioner cannot challenge the orders passed by respondent, by the BDA. There being no allegation of malafide or bias by the petitioner against either respondent number 1 or the other respondents, the decision of the BDA cannot be faltered with. He submits that it is in the discretion of the BDA to allot the line, and the same cannot be questioned by way of the present writ petition filed under Article 226 of the Constitution. In this regard, he relies upon the decision of the division bench of this court in Aikubu Nagar Residents Welfare Association, Aikubu Nagar Residents Welfare Association, another was BDA, ILR 2002, Karnataka 4705, more particularly para 2, 6, and 10 thereof. By relying on the above decision, he submits that it is only when there is a gross violation of fundamental right or the issue touches the conscience of the court that directions could be issued by the court. The present case is not one which comes within those exceptions, and as such, the writ petition is required to be dismissed. See, Manmohan PN, Learned Counsel, appearing for respondent number 2, would submit that the petition itself is misconceived for the reason that misconceived and not maintainable, for the reason that the petition has been filed by a school, by the school and not by the trust. And in terms of section 2D, rule 2D of the rules, it is only an institution which could be allotted a civic community site. The present petition not having been filed by the trust but by the school, not satisfying the requirement of rule 2D, the petition is liable to be dismissed on this technical aspect itself. He reiterates the submission made by the senior Sri Gurdas Kanur, Learned Senior Counsel, that there is no vested right created in favor of the petitioner. And he further reiterates that the petitioner, having already been granted a particular land, cannot seek for further allotment. Insofar as consideration of the application, he submits that the application of respondent number 2 has been considered by the BDA insofar as the BDA in the meeting, the committee in the meeting, has adverted to the fact of the person in whose name the trust respondent number 2 has been established was a very noteworthy poet in the state of Karnataka in Kannada language, he having rendered yeoman services for the propagation of the Kannada language, and therefore the trust now being established, a trust now established in his name, also having rendered services by undertaking social, cultural, music, drama, and other activities. The respondent number 2 was eligible within the meaning of, within the terms of Rule 6 of the rules. The objective of the respondent number 2 has been considered in term which satisfies the requirement of Rule 7. And as such, the allotment of civic community site cannot be questioned, nor is it amenable to be set aside. He relies upon the decision of the apex court in Chandra Singh and others, the state of Rajasthan and another, reported in 2003, 6 SCC 545, more particularly para 43 thereof. Same is reproduced here under for easy reference. Correct. None has appeared for respondent number 3. Learned AGA adopts the submissions made by Sri Gurudas Kanu, learned senior counsel, and further submits that the matter is in dispute. Matter is a dispute between the petitioner and the other respondents, the state being only a formal party. Heard, Srimati Rosa Paramal, learned counsel for the petitioner, Sri Gurudas Kanu, learned senior counsel for respondent number 1, Sri P.N. Manmohan, learned counsel for respondent number 2, and AJ for respondent number 4. It is not in dispute that the petitioner has been allotted plot number 36, which is a portion of plot number 36, measuring 3969 square meters in site number 36 of Saraki first phase for the purpose of running of the school. It is also not in dispute that the petitioner has established a school. The petitioner school has been established in the said plot, and the school is running with nearly about 850 students. The preliminary objection raised by Mr. P.N. Manmohan, the counsel for respondent number 2, is that the petition has been filed by a school, whereas it ought to have been the trust which should have filed the petition. And therefore, the school not having any legal standing, the petition is liable to be dismissed. A perusal of the petition indicates that the petitioner's school, that there is a specific avowment that the petitioner's school is managed by the Bolar Education Trust, which has been established in the year 1985 to impart education. A perusal of the application which has been filed, produced at Annexure P, also indicates that the application has been filed by Bolar Education Trust, represented by its trustee, and the said application has been filed for the purpose of carrying out social and cultural, establishing a social and cultural center by stating that the petitioner has been running a school in plot number 36 bar A of JP Nagar, first phase. It is also stated in the said application that the petitioner has been attempting to obtain the property, obtain the allotment of the property for the last 22 years. The petitioner has also made payment of the requisite amounts. The requisite amounts have also been paid by Bolar Education Trust, in as much as the demand draft has been obtained by Bolar Education Trust, and the receipt issued by the Bangalore Development Authority is also in the name of Bolar Education Trust. In fact, the receipt issued by the BDA also indicates that it is issued to Bolar Education Trust, which is running the petitioner's school. In view of the above, the writ petition having been filed in the year 2014, I am of the considered opinion that it would amount to a travesty of justice if the submission of Sri P.N. Manmohan, learned counsel for the respondent number 2, is accepted at this stage, and the petition dismissed on such a mere technicality, when both the petitioner and the respondents are clearly aware that the petitioner's school is established and run by a trust, and the said trust satisfies the requirement of Rule 2D of the rules. The matter could have been different if the said requirement had not been satisfied. Since I am of the considered opinion that those requirements have been satisfied, and more so taking into consideration that the BDA had earlier allotted a plot measuring 3969 square meters, such a technical objection could not be made. This court, while disposing WP number 15901 of 2006, by its order dated 7th August 2007, had issued certain directions. The same are reproduced here under 504, page 42, 43, 44. A preview of the above directions indicates that the authority is directed to strictly follow the rules while disposing the balanced civic amenity sites. There was specific reference made to Rule 3 as regards notification and inviting applications. This court had specifically stated that notwithstanding the order, it was open to the petitioner as well as the second respondent therein, that is the Hindustan Petroleum Corporation Limited, to approach the Bangalore Development Authority when it is offered for lease to apply for the same, and the same to be considered by the Bangalore Development Authority in accordance with law. When the said order was passed, there was no submission made by the Bangalore Development Authority that the petitioner was not eligible for further allotment, since there is already an allotment of a plot measuring if at all such a submission had been made, this court could have probably considered the same. Having conceded at that point of time for the petitioner to apply in the event of the notification being issued, it would not now be permissible for the Bangalore Development Authority to contend that the petitioner having been allotted a land already could not have applied for further allotment and or file the present petition challenging the allotment made to respondent number 2 and 3. A peril of the rules of 1989 also does not indicate any prohibition for an allottee to apply for further allotment, to allottee of civic community site to apply for further allotment. Correct. Rule 7 reads as under. A peril of the same would indicate that apart from the objective and activities of the applicant from a financial position, the bona fides of the applicant, what is required to be considered by the BDA is the location, present location of the institution of the applicant, the benefit likely to accrue to the general public of the locality, as also the need of the civic amenity site by the institution for providing the civic amenity in question. In the present case, as observed above, there is no dispute of the petitioner running a school with 850 students in the adjoining property. The petitioner has applied for and requested for allotment of the adjoining site, since the same had already been put to use as a playground and that the said property would be required for the trust, for the school and the students. It was therefore, it was but required for the BDA, while passing the resolution and taking a decision on the applications received, by adverting to all the parameters which have been enumerated in Rule 7. the Bangalore Development BDA also ought to have adverted to the requirement of all the applicants and not only the successful applicant in whose favor the BDA has granted the site. A perusal of the resolutions aforementioned indicates that insofar as plot number 36 AP1, there are 16 applications received, and insofar as plot number 36 AP2, there were 20 applications received. The perusal of the resolution does not indicate even the name of those applicants, the purpose of the application filed by them, let alone the parameters which have been fixed under Rule 7 of the rules of 1989. In this background, though Shri Gurudas Kannur Learned Senior Counsel has submitted that all the aspects have been considered and the discretionary power of the BDA has been exercised in a proper manner, I am unable to accept the said submission, since ex facie, none of the requirements of Rule 7 have been considered. The discretionary power vested with the BDA is also required to be exercised in a proper and required manner, and the said discretion is not absolute. The BDA, being a statutory authority, is required to discharge its functions within the parameters fixed by the statute and the rules. A perusal of the resolution dated 22/10/2013 at item number 7 and 8 would indicate that the BDA, that the committee having taken into consideration that there was an earlier allotment which had been set aside by this court, had gone ahead and allotted the same once again to the very same respondent number 2 and 3, except to state that this was in pursuance of a notification issued under Rule 3 and not the allotment made outside the purview of the rules. Correct. The manner in which the resolutions are worded and the manner in which the consideration has been given clearly indicates that the decision was it was a pre-decided decision, and only an empty formality of issuing a notification under Rule 3 has been complied with the BDA before reallotment of the plots, civic community plots, to respondent number 2 and 3. Last condition of Shri P.N. Manmohan, Learned Counsel for the petitioner, for respondent number 2, is that the notification was issued for the purpose of establishing social welfare center insofar as plot number 36 AP1 and a technical training center insofar as plot number 36 AP2. Therefore, he contends that the very purpose for which the notification was issued, not being one for which a school, not being one which the school can make use of, no such allotment could even be sought for by the petitioner. Correct. It is due to the said submission that this court is constrained to observe the manner in which respondent number 1 BDA is acted, inasmuch as this court had directed the BDA to issue a notification and permitted the petitioner to participate in the same. The allotment which had been made in favor of respondent number 2 on an earlier occasion was for a social welfare center. And the allotment which had been made in favor of respondent number 3 was for a technical training center. And it is glaringly apparent from the notification that it is only to satisfy the requirement of respondent number 2 and 3 that the purpose of the notification, as purpose of inviting application has been shown as social welfare center and technical training center. This, in my considered opinion, appears only to disqualify the petitioner, which is not permissible. Correct. One other contention, this is the last contention. The last contention which has been advanced by Shri P.N. Manmohan is that a writ of certiorari being a discretionary remedy, this court could refuse to extend the benefit of the discretionary relief even though the decision may be erroneous. So the grant of a certiorari would come in the way of substantial justice being done. This submission is made on the basis of, by relying on para 43 of the judgment in Chandra Singh's case, extracted supra. The peril of the said para 43 indicates that the observation made by the Honorable Apex Court was made while considering the fact that even if the writ petition is considering the fact that if the writ petition were to be allowed and an illegal order quashed, the same would revive another illegal order. In the present case, I am of the considered opinion that the quashing of the orders sought for in the present petition would not revive any illegal order, but would only come to the rescue of the petitioner who has been made to suffer from an illegal resolution passed, which is contrary to and violative of Rule 7 of the rules of 1989. In view thereof, I pass the following order. Writ petition stands allowed. The allotment dated 6/12/2013, bearing number so and so at annexure T, insofar as lot number 36A P2 in favor of third respondent is quashed. Allotment letter dated 9/1/2014 at annexure V in favor of second respondent is quashed. The matter is remitted to the first respondent to strictly consider the applications in accordance with the rules, which would include Rule 7 among other rules, by ascertaining the merits and demerits of all the applicants within a period of 3 months from the date of receipt of a copy of this order. We notice that it is SPCL. That is HPCL. There's a mistake in the petition. We'll correct it. Of course, this will undergo corrections. I don't know that. Earlier petition, last earlier order was with reference to HPCL. Yes. IA1 of 2014 daily order. IA1 of 2014 is allowed, except in the regional statement and support of the said application. You had to wait because that was going on. At least some matter. These are the only two matters which have gone on today. That's something for everybody to learn. Yes.
When acquisition is taking place for the purposes of a national area, it's a very short. It may not be facts. There are points. There's a synopsis that we already filed.
In which matter has it been filed, Mr. No. It says citations. 15th of July citations, 15th of March synopsis. Yes. Yes, please.
They are the absolute owners of the land. There's no dispute so far as that particular aspect is concerned. However, the lands that are being acquired so far as these petitions are concerned, those for the national highway 206. Notification under section 3A is issued on 27/7/2006. It covers all the petitions. There are the minority petitions that raise separate objections. So far as the compensation and also demanding that the application should be given to them under the 2039. That my lord is not considered an award which should be passed. When the fear of disposition came about, at that time, the petitioner approached the Honorable Court. The Honorable Court was granted into order for them not to be dispossessed from their lands. And liberty was also granted for the petitioners to go before the administrator for enhancement of compensation. Just to clarify, there is no challenge to the land acquisition person.
You're only concerned with the compensation and rehabilitation.
Compensation by before the administrator that will take its course.
By now, the road is also formed.
My lord, we are not yet dispossessed.
We are still.
Yes. The only question over here, my lord, is insofar as that resettlement and rehabilitation is concerned. So we are not putting a burden insofar as that.
We were expecting the other argument, road is formed, now we have already resettled, there's nothing to resettle.
In fact, my lord, we are also, when the acquisition was taking place, we drew attention to the local authorities over there that the laws are resettled. Guidelines have been issued by the NHI saying that we should be resettlement and rehabilitation has to be done first. Please carry out the process simultaneously. If you do that, then this then the entire matter gets settled over there.
Yes.
In fact, in writing, we have written to the authorities consecutively, saying, please do this. Unfortunately, the authorities, they're not done that. What they do, my lord, in fact, not just sees the award, that itself will give an idea of how the authority could be. My lord, is petition
11642, we are the first one.
That's right.
No. It was 10. 1164.
1164.
1013.
Yes. You want to petitioner Manoj.
Petition. Yes. FR number.
Yes. The next year, page 57 is there.
Yes.
The relevant portion is at page 61. Serial numbers 1, 2, 3, 4, 5, 8, 9, 10 are the lands of this particular these petition.
1, 2, 3, 4, 5.
8, 9, 10.
Yes.
What is this page 71?
Yes.
RFCP, right to fair compensation, the transparency manipulation is their and 2013 schedule 2 and schedule 3 university state and ಭಾರತ ಸರ್ಕಾರದ ಗ್ರಾಮೀಣ ಅಭಿವೃದ್ಧಿ ಮಂತ್ರಾಲಯವು RFCP ದತ್ತವಾಗಿರುವ ಆದೇಶ ಆದೇಶದಲ್ಲಿ ಮೇಲ್ಕಂಡ ಸ್ವಾಧೀನ ಪ್ರಕರಣದಲ್ಲಿ ಪರಿಹಾರದ ಮೊತ್ತವನ್ನು ಶೆಡ್ಯೂಲ್ 1 ತಯಾರಿಸುವುದಕ್ಕೆ ಹಾಗೂ ಪುನರ್ವಸತಿ ಮತ್ತು ಪುನರ್ವ್ಯವಸ್ಥೆ ವಿಷಯವನ್ನು ಶೆಡ್ಯೂಲ್ 2 ರಲ್ಲಿ ಮೂಲಭೂತ ಸೌಕರ್ಯ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಬಗ್ಗೆ ಶೆಡ್ಯೂಲ್ 3 ರಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳು ಆಧಾರದಲ್ಲಿ ಎಲ್ಲಾ ವಿಧಾನದ ಭೂಸ್ವಾಧೀನ ಪ್ರಕರಣಗಳಿಗೂ ಅನ್ವಯಿಸಬೇಕಂತ ತಿಳಿಸಲಾಗುತ್ತದೆ. ಅಷ್ಟೇ ಅಲ್ಲ, ಈ ಆದೇಶವು ದಿನಾಂಕ 19/2015 ಜಾರಿಗೆ ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಪ್ರಾಧಿಕಾರ ಕೇಂದ್ರ ಸ್ಥಾನದಿಂದ ಕಳಿಸಲ್ಪಟ್ಟಿರುವ ಆದೇಶ ಸಂಖ್ಯೆ 19/2015 ಮೇಲ್ಕಂಡ ಹೊಸ ಕಾಯ್ದೆ ಅಂಶಗಳನ್ನು ಅಳವಡಿಸಿಕೊಂಡು ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಜರುಗಿಸಲು ನಿರ್ದೇಶಿಸಿರುತ್ತದೆ. ಭಾರತ ಸರ್ಕಾರ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಸಚಿವಾಲಯ ಆದೇಶ ದಿನಾಂಕ 2015 ಮತ್ತು RFCP ಕಾಯ್ದೆ ಸೆಕ್ಷನ್ 31(1) ಮತ್ತು 32 ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಪೈಕಿ 3ನೇ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ವಿವರಿಸಿರುವ ಮೂಲಭೂತ ಸೌಲಭ್ಯಗಳನ್ನು ಒದಗಿಸುವುದು ಪ್ರಸ್ತುತ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 2007 ಶೆಡ್ಯೂಲ್ ವಿಭಾಗದ ಯೋಜನೆಗೆ ಅನ್ವಯಿಸುವುದಿಲ್ಲ. ಏಕೆಂದರೆ ಈ ಯೋಜನೆಯು ಯೂನಿಯನ್ ಪ್ರಾಜೆಕ್ಟ್ ಯೋಜನೆ ಯಾವುದೇ ಗ್ರಾಮವನ್ನು ಪೂರ್ಣವಾಗಿ ಭೂಸ್ವಾಧೀನ ಮಾಡುವುದಿಲ್ಲ. ಪುನರ್ವಸತಿ ಮತ್ತು ಪುನರ್ವ್ಯವಸ್ಥೆಯ ಶೆಡ್ಯೂಲ್ 2 ಕುರಿತಂತೆ RFCP ಆದ ಕಾಯ್ದೆ 2013 ಸೆಕ್ಷನ್ 31(1) ಅನ್ವಯವಾಗುವ ಪ್ರಕರಣಗಳಿಗೆ ಶೆಡ್ಯೂಲ್ 2 ಅನ್ವಯವಾದಲ್ಲಿ ಸೂಕ್ತ ಪರಿಹಾರ ನೀಡಲಾಗುವುದು. So section schedule 3 rightly they said that no villages will exist, so that is not going to apply. But schedule 2, what they say is that section 31(1) ಅನ್ವಯವಾಗುವ ಪ್ರಕರಣಗಳಿಗೆ ಅನ್ವಯವಾದಲ್ಲಿ ಸೂಕ್ತ ಪರಿಹಾರ ನೀಡುವುದು. So if it applies, the point is when is this exercise going to be carried out? How is this exercise going to be carried out? Admittedly, if we fall under section 2, if we are entitled to those benefits, it will be given to us. But the award has already been passed. Now the question of disposition comes. My humble submission is this: when the Land Acquisition Act 1894 when it existed, the Honorable Supreme Court member in Ramji Gupta's case and Goro Raj's case, in both cases it says that this is an outdated provision. It has to go. You have to look at better ways to acquire land and rehabilitate people. It is in compliance of that, or rather taking direction from them, that 2013 this act comes to be passed. Now this act may not do this statement, what this is the act, section 105. What happens when the act was passed?
Yes.
Section 105. Subject to
yes.
Provisions of this act not to apply in certain cases and to apply with certain modifications. Subject to subsection 3, the provisions of this act shall not apply to the enactments relating to land acquisition specified in the 4th schedule. I go to the 4th schedule.
Subject to subsection 2 of section 116, the central government may by notification omit or add to any of the enactments specified in the code schedule. The central government shall by notification within 1 year from the date of commencement of the act direct that any of the provisions of the act relating to the determination of compensation in accordance with the first schedule and the application of these settlements specified in the second and third schedules being beneficial to the affected families shall apply to the cases of land acquisition under the enactment specified in the fourth schedule or shall apply with such exceptions or modifications that do not reduce the compensation or derivate the provisions of the act relating to compensation reapplication and VAT settlement as specified in the notification as the case may be. My God, may please the fourth schedule.
Yes.
Fourth schedule, entry number 7. The National Highways Act. As on the date of this law came into force, the provisions of this act were not made applicable to the national acquisitions under the National Highways Act by design. What happens thereafter? I find memo dated 15/3/2020, which produces the various ordinances passed by the central government, making this law applicable to acquisitions under
along with the synopsis. Memo to produce documents. Yes.
the first ordinance was dated 21/12/2020. See, section 10 of the ordinance. At page 4.
Yes.
In Principal Act, in section 105, for subsection E, the following subsection shall be substituted. The provisions of this act relating to the determination of compensation in accordance with the first schedule, the application of leases in accordance with the second schedule, and infrastructure amenities in accordance with the third schedule shall apply to the enactments relating to land acquisition specified in the fourth schedule with effect from 1st January 2015. So this is now made applicable. I got the piece at page 6. So the subsequent one, dated 3rd April 2015. This is the piece section 12 at page 8. Provision is etiquette, sort of the repromulgation, again extends the number of benefit to acquisition. And what we please see, third one. This is dated 30th May 2015 at page 12. Page 12 of the bottom of the page. Yet again, this is repromulgation. The provisions of this act relating to the determination of compensation in accordance with the first schedule, the application and resettlement in accordance with the second schedule, and infrastructure amenities in accordance with the third schedule shall apply to the enactments relating to land acquisition specified in the fourth schedule with effect from 1st January 2015. Thereafter, my lord, what the central government is issues a notification dated 28th May 2015. That, my lord, is on page 20. The English version of this one page. It's issued by the Minister of Public Department. It's an order dated 28th August 2015. It makes reference to all of the orders. And from the fourth paragraph of the law. And whereas the central government considers it necessary to extend the benefits available to the landowners under the RFC LAR Act, similarly to this landowners whose lands acquired under 13 enactments specified in the code schedule, and
And accordingly, the Central Committee has decided to extend the beneficial advantage to the landowners and uniformly apply the beneficial provisions of the RFCP Act relating to the determination of compensation and rehabilitation resettlement as well made applicable to cases of land acquisition under the said enactments in the interest of the landowners. Now, therefore, in exercise of the powers conferred by Section 1 of Section 113 of the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement Act 2020, the central government hereby makes the following order to remove the aforesaid difficulties, namely, the order may be called the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement. Remove the difficulties of this 2015. It shall come into force with effect from the first day of September 2015. The provisions of the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement Act 2030 relating to the determination of compensation in accordance with the first schedule, rehabilitation resettlement in accordance with the second schedule, and infrastructure amenities in accordance with the third schedule shall apply to all cases of land acquisition under the enactment specified in the fourth schedule of the Act. But this is never explicit. There is no ambiguity as to whether this applies or not. No matter in the statement of objections, there seems to be at certain points it says yes, it is applicable. At certain points, it says that it cannot be applicable. However, my only submission is this. So far as the compensation is concerned,
yes.
so far as compensation is concerned, under the National Highways Act, I have a remedy. If I am not satisfied with the compensation that has been given to me, I can go before the arbitrator, Section 3G. That is what I done. I sought leave from the Supreme Court when I filed this petition, and I am before the court in so far as the monetary compensation is concerned. But in so far as my rehabilitation and resettlement entitlements are concerned, even after filing this petition, no steps have been taken by the respondents to say what am I entitled to. I want to please see the second schedule.
Yes.
Second schedule. There are not 11 benefits that are given to a land user. Various types of benefits. For instance, my lord, with PC clause 4, which is extremely crucial. One of these cases, in fact, the Supreme Court had said that you have to classify the various kinds of acquisition that is taking place and come up with various models of rehabilitation for each of them. What they've done is that choice of annuity or employment. The appropriate government should ensure that the affected families are provided with the following options. Where jobs are created through the project, after suitable training and skill development required, make provision for employment at the rate not lower than the minimum wage provided. Or one-time payment of 5 lakhs per affected family. Subsistence grant for displaced families for a period of 1 year. There are 11 such benefits. You see just below what is below section, the second schedule. The applicable provisions are section 31(1), 38(1), and 105(3).
Where are you reading?
The second schedule, the title second schedule.
Yes. Section 31(1), 38(1), 105.
Can I just for a moment? How are these? What does the law say in terms of arriving at what benefits each affected person is entitled to? The Act has a very clear mandate about how that has to be.
Yes. Yes.
Rehabilitation and resettlement award for affected families by collector. The collector shall pass rehabilitation and resettlement awards for each affected family in terms of the entitlements provided in the second schedule, which I just mentioned. The rehabilitation and resettlement award shall include all of the following. Each of those points that was over there belong to each of the provinces. Provided that in case any of the matters specified under clauses A to A are not applicable to any affected family, the same shall be indicated as not applicable. So what this contemplates now is that exercise is carried out.
And according to you, this has to be done before you're dispossessed.
Yes, and the reason I'm saying that is section 38. The law to recall section 31 and 38 are related to the second schedule. Section 38. Power to take possession of land. Collectors should take possession of land after ensuring that full payment of compensation as well as rehabilitation and resettlement entitlements are paid or tendered to the affected persons within a period of 3 months for the compensation and a period of 6 months for the monetary part of rehabilitation and resettlement entitlements listed in the second schedule, commencing from the date of the award date under section 30. Provided that the components of the rehabilitation resettlement package in the second and third schedules that relate to infrastructural entitlements shall be provided with a period of 18 months. I am on the main provision. It contemplates payment of these entitlements.
38.2. You're on 38.2.
38.2. The collector shall be responsible for ensuring that the rehabilitation and resettlement process is completed in all its aspects before displacing the affected families. So this award that is contemplated under section 31, it begins award at section, but process, the award is a culmination of what is contemplated from section 16 onwards. At section 16, award is a census that is contemplated. A draft R&R scheme is contemplated again under section 16.2. Well, it's settled down. If the law says something has to be done in a particular way, it can only be done in that particular way. And when an order is passed, when ordinances are passed, making these provisions applicable to acquisition even for land, for the national areas, the procedure will have to be followed from here. The question that arises about what is said in the award, if it is applicable to you, it will be done. The law does not contemplate that. The law contemplates the process from section 16, culminating in an award at section 31, ensuring that it's given to all the affected persons under section 28. Thereafter,
they said it will be done, so they will do it.
But we have asked them several times about when do you plan to do it, how do you plan?
You have not been dispossessed, you are still staying in your land.
In fact, my lord, my clients were telling me, but then, my lord, they are really not, they are not interested in pursuing this litigation beyond getting what is due.
Continue using the land until they dispose. Before they dispose, they have to do it.
I made reference to them in my synopsis.
In the document that you refer to, they said, if applicable, they will do it. And to the extent applicable.
Section 31, the culmination of that process has to be, that is the mandate that we see. Even the relief that we are seeking, the Lord will please my repetition. The relief that I am seeking from this one. I'm asking for a mandate so that we comply with the provisions of the law. The second way I want to proceed because the arbitration proceedings are they are going ahead. So that can continue, but I don't want to
Yes. Yes, we got 15-7.
Versus Karnataka private limited matters. They are imposing yes, private and private. The relevant paragraphs number 59, paragraphs 23, 26, 40, 20.
You have furnished copies? Please furnish copies. One set has to be given to the. Basic minimum courtesy.
Both my would have gone up. 2 times they passed over, I'm waiting. After both of one line of is faster, other line of is not happy.
Then we can only have it on Friday.
Monday is not inconvenient.
13th is also fine.
27 Friday, there are wages not gets.
Friday or Monday. Monday is fine.
They don't want to again
Please share, both of you share. You give everything that you want to rely on. Third, Sri Christian B. Rosario, Learned Counsel for the petitioner in part. What about who is appearing for? Who is R1 in all these matters? NHA is which? R1 is Union of India. But there are different lawyers' names which have been shown. Yes. So, R3 is NHA. SLO NHA. R1 is Union of India. R2 is the state government. Right. So in only one matter, there is a different counsel. Or Sri Christian B. Rosario, Learned Counsel for the petitioner in part. Relist on 30/5/2022 at 2:30 p.m. Yeah. For further view. Relist on 35/2:30 for further view.
Further hearing the part and further hearing next. Wrapper.